are there.
My signatures are there, my lord.
Then of the notary was on 6/5/2000.
Yes, my lord. Online, my lord. Online, when I saw them, I asked them to go and notarize it. Then the notary has been done, my lord.
So very serious matter. If their signature,
My lord.
your signature is of 6/5/2024.
My lord.
The notary was done at the petition was notarized.
Yes, my lord.
At Ludhiana.
Yes, my lord. There
you were at Ludhiana.
No, my lord. May kindly see page 25. That is a different lawyer, my lord. My lord, may kindly see page 25.
Yes.
My lord, may kindly see at the bottom.
Why should we see 25? Come to Wakalatnama.
Yes, your lordship. Wakalatnama copy is it is identified by a notary in Ludhiana, my lord.
So signature attested 6th May. You signed on 6th May.
No, my lord. My lord, are looking at the Wakalatnama. My lord,
Yes.
my lord, I don't have a copy of the Wakalat.
They have.
Well.
It's a classical case of professional misconduct.
Hello. My lord, may kindly see their signature has been notarized, my lord, not ours, my lord. We had not signed it, my lord.
You
Theirs.
have signed it.
No, my lord, we
But the
filed
copy-
it.
No, Wakalatnama.
Yes, my lord.
First name is yours.
Yes, my lord.
You
It's
have
by-
signed it on 6th May.
So when did you sign?
Lord,
Why have you not mentioned
no, my lord,
the date?
my lord, we-
Attested whose signature?
my lord, attested
On
the
signature.
no, my lord,
Executing
execute.
yours.
No, my lord, execute and signature. My lord. No, my lord, may kindly see the affidavit along with it, my lord. My lord, page 25. This Wakalatnama and affidavit was notarized in Ludhiana, my lord. Not after, with our signature, my
Who
lord.
gave you the Wakalatnama?
My lord, it was sent by post, my lord. Wakalatnama and this affidavit, my lord. My lord, we have got the entire trail, my lord. If your lordship wants, we have shared it.
No, we'll cause an inquiry into it.
My lord, we had shared it through emails and WhatsApps. After that, my lord, they printed it out, signed it, notarized it, and then sent it to us, my lord. Our signature was not notarized, my
Then
lord.
when have you signed that?
My lord, pursuant to it, my lord. Not 6th May, my lord. Not
When
6th
you have
May.
not put your signature.
I'm
You have
sorry.
not put the date.
Mr. Counsel,
Well,
your
that-
signatures are there on the petition also.
Yes, my lord. We have received it, my lord. My lord, may kindly see this was solemnly declared on 6th May, but it was filed later on, my lord. It was filed on 9th May,
Yes, we understand.
my lord.
It was notarized on 6th May
Yes, your
in
lordship.
Ludhiana.
Yes, your lordship.
Filed in on 9th May
Yes, your
here.
lordship. Yes, your lordship.
So, and who brought this affidavit from Ludhiana?
My lord, it was sent by post, my lord. We have the postal receipts.
From 6th to 9th.
My lord, I have to check, my lord. We have the postal receipts, my lord.
Very serious matter. And your signatures are there
Yes, your lordship.
on the petition also.
After we received it, my lord, we have.
How did you sign that?
My lord, we didn't attest the signature, my lord. We have just signed the. I apologize.
Mr. Counsel, your signatures, whose signature is this? On each and every page of the petition?
My lord, our signature, my lord. Our
Why?
signature.
Why your signature is there when it was notarized on 6/5
My lord.
and the document was not there with you on 6/5?
Yes, my
Then how your signatures are there?
I apologize, my lord. Personal.
What is the question of apologize?
After it was notarized, my lord, we have put the signature while filing, my lord. Not while it was notarized, my lord.
And what about the High Court rules? So notarized affidavits are accepted under the High Court rules.
We have been doing notary here, my lord.
Then we are seeking your explanation. When the matter was taken up on 17/5/2024, we had dismissed the writ application. Stop. However, while dictating the order in chambers, we have noticed certain discrepancies in filing of the present writ application of serious nature. Stop. The petitioner claims to be claims to be a non-profit, non-government organization having its office, a registered office at 86C Model Gram, Kochar Market, Ludhiana. Stop. This notarized application has been filed, attested by the Notary Public, District Court, Ludhiana, bracketed Punjab, on 6/5/2024. Stop. There are altogether 8 learned advocates who have signed the Wakalatnama said to have been executed on 6/5/2024 by the executant at Ludhiana. Full stop. Learned advocates are regular practitioners of this court. Full stop. Next. It was further found that the signatures of one of the learned counsel who has signed the Wakalatnama figure on each and every page of the affidavit of the petition, which has been filed on affidavit notarized on 6/5/2024 at Ludhiana. Full stop. Next, Mr. S.S. Mohanty, learned counsel appearing on behalf of the in the aforesaid background, the matter was ordered to be listed under the heading to be mentioned for seeking clarification from learned counsel who had argued the matter on 17/5/2024. Full stop. In response to a query made by this court, Mr. Mohanty has informed that the notarized writ petition was received by, along with Wakalatnama, was received by you,
Yes, Your Lordship.
was received by him through post, whereafter the present writ application came to be filed on 9/5/2024. Stop. What do you want? So will you swear an affidavit or who will swear affidavit?
My Lord, as Your Lordship, please, I'm sorry, my Lord, I'm not able to understand. I'm not able to follow Your Lordship. As Your Lordship pleases me. Your Lordship. I shall withdraw it if Your Lordship.
Why should you withdraw? Please see,
Yeah.
I am not inclined to initiate any action against any lawyer.
My Lord.
I never do it. But if I am compelled, I am always ready to do that.
No, Lord, I won't dare to do that.
Please, we are adjourning the matter. Come on the reopening day
Well.
and tell us
Well.
whether you realize the mistake or not.
I'll do so.
If you realize, then it's different. And this is my advice to all the young lawyers. We give indulgence because we want you to grow. Don't take a shortcut.
No, Lord, I apologize.
Never do that.
I give my unconditional apology, my Lord. I'm not.
We are not required to. But the only thing which we want is, please realize,
I bow
there
down.
is no shortcut in this profession.
I bow down, my Lord.
You follow the procedure, you follow the law, and the most important thing is that your conduct should be unquestionable.
I'm embarrassed, my Lord. I'll see.
This as requested on behalf of the petitioner. This is the matter under the same heading on opening day, 10:30. Please.
No, my lord, they will have to learn.
You are not required to explain anything to the court. Just see if you can correct yourself, please correct yourself. And if you are so sure about the stand which you are taking, you must take that stand. It is not that despite your stand taken, we will be taking any action against you. I will be directing for any action against you. But yes, we will see what can be
My
done.
Lord, I'll consult the seniors of the bar, my Lord. My Lord, I'll also learn, my Lord. I'll consult my senior in the bar, my Lord. I'll learn if
You
I'll come-
introspect. Go through the High Court rules.
My Lord.
Why there is a format prescribed for execution of Wakalatnama?
My Lord.
Why should you not accept Wakalatnama if the person who has executed that is not in front of you?
My Lord.
These are the things. Why, whether an affidavit notarized at Ludhiana, based on that, you can file an application here in Orissa High Court or not. What do the High Court rules provide?
Well.
Please examine. We are disturbed.
Well.
It is not that we are against you or against any member of the bar.
My Lord, I'll try my best to assist, my Lord.
Yes, next.
Item number 2.
You can-
May I please, your lordship? This matter, my lord, has been listed as per the order of this honorable court on 20th May 2024. Only because the lawyer who is appearing on behalf of Chief Electoral Officer, Government of India, will appear and assist the court. Yesterday, this order was passed, my lord.
Yes, Mr.
I have no information about this order, any order was passed by my lord.
Please come at 2. Please see the orders.
I have downloaded yesterday, lord. I have received one instruction regarding permission, there is a high power committee constituted, headed by chief secretary, you also kindly see. That proposal is to go through chief secretary. And thereafter it has to be forwarded to the election commission of India for immediate permission. But I have no idea whether that letter was issued through chief secretary or.
He says chief electoral officer was.
Those documents were not with me, so we could not verify.
Yes, whether any request has gone.
Yes, that request has gone.
That request has gone to the chief electoral officer.
My lord, my instructions of the CEO has not received the order, copy of the order.
No. Instruction from the government of Odisha.
Government of Odisha had made a request to the chief electoral officer.
My lord, that is to go through chief secretary. There is when model code of conduct implemented, you also kindly see the guideline of the election commission. When model code of conduct is implemented, my lord, there is a high power committee constituted under the chairmanship of chief secretary. That is to go through the department concerned is to send to the chief secretary, and the chief secretary is to forward to the CEO, then to the election commission.
See,
Can I submit, sir?
government is. Yes. Government is.
So whether the proposal has been clarified by
My lord,
this committee.
So
the
can I
proposal
submit,
has
sir?
been, my lord, the DG is there. Proposal has been sent to the electoral officer. But
The
So the
proposal has
committee-
been sent by,
So the
whether
committee
it has
met,
been cleared by this high powered committee or not.
so the high powered committee met on 16th. On 17th, they communicated it to the chief electoral officer. Chief electoral officer has sent it on 18th to the Election Commission of India. And currently it is pending with the Election Commission of India from 18th.
Then I'll take instruction, I'll ask them to comply, your lordship.
At 2.
Yes, I'll take it. A copy of the letter sent by to the CEO be supplied to me. so
That they'll
we
give
can-
you.
that I,
Yes.
that
Oblige me.
Item number 3.
My lord, first, I'll pray, my lord, this matter to be taken up on 19th, please.
19?
19th, after reopening, immediately after reopening.
Yes.
Of course, the contempt matter has been fixed to 26th. This writ appeal has been filed against an interim order. You'll also remember
Please
that case.
decide. You will have to see.
Actually, I told my learned seniors,
Both of us.
if they don't agree,
We
I will
consider
let it
your
up.
appeal to
Let
be
the appeal
allowed.
be allowed. Both of us considered that let the writ appeal be allowed.
You also see the order, which is, because you wanted that also on that date. And by, because you wanted the instruction from his client that we are going to pass this order, the order which has been passed, that will be set aside, it will be sent back. You also look to the order, the impugned order.
The include order only, the alone single judge has said that file a better so cause, the so cause is rejected. That is what.
So therefore, the order has not been rejected.
Yes, yes,
Yes.
yes.
And you can take this stand that yes, this is our order, do whatever you want.
That's
My lord, here,
We may either punish you.
Lordship have also
Oh,
yeah,
suggested, yes, suggested, since the affidavit, compliance affidavit has been rejected, which is not in contemplation of the contempt proceeding. So at least that order should go. Because so far as the honorable single judge is concerned, he can proceed the contempt in accordance with the contempt of court.
That is the,
That is
that
exactly
is,
Lordship
so
intended.
we are
is
not
intended,
required to
exactly.
say anything.
No,
No, rejection of the affidavit,
yes.
rejection of the, unless the so cause is rejected, how the contempt court will proceed further?
Yeah.
Either the so cause is to be accepted or
Or
rejected.
rejected.
And single judge has decided to reject it.
And they undertook also to file an affidavit. That is also the order.
Let us see, as requested.
Then, all right.
Think
That's
about
like skipping it to 19th or 20th.
20th,
20th.
20th, as requested on behalf of the appellant.
Item 4. My lord, may it please the lordships. This is the matter, my lord, which we were arguing yesterday. I have filed a small memo. The lordship sees, my lords. I will not take more than 5 minutes. My lord, enclosed is a notification of 12th September 2023. My lords have it. 12 September 2023.
Yes.
Kindly see, my lord. Now, therefore, in exercise of past comfort, my lords have it that line. That third paragraph. Now, therefore.
Yeah.
Now, therefore, in exercise of past comfort by subsection 1 of section 56 of the Motor Vehicle Act, the central government hereby makes the following rules to amend the Central Motor Vehicle Rules 1989. These rules may be called so and so. They shall come into force from the. So, therefore, my lord, the date is they come into force from 12 September 2023. Now, what it says is, in Rule 62 of the Central Motor Vehicle Rules 89 and Sub-Rule 1, for Clause B, the following shall be substituted. Renewal certificate of fitness in respect of transport vehicles, 2 years for vehicles up to 8 years, and 1 year for vehicles older than 8 years, provided that the fitness of the vehicle of the category of heavy goods, my lords, kindly turn over the page, lords. Heavy passenger motor vehicle, medium goods, vehicle medium passenger motor vehicle, and light motor vehicle shall be done mandatorily. Kindly note, my lord, shall be done mandatorily through a automated testing station registered under Rule 175 with effect from 1st of October 2024. Therefore, that is the sanctity of that date of 1st of October 2020 as per the law. Now, my lord, may kindly see that affidavit which I had filed on the last occasion, that is 15/5/2024. This is page 610. My lord, running page 610. My lord, Justice Raman has 610. My lord, where we had said, my lords, that Form S.
Just. What is that?
Lord, there is paragraph 7. This is the affidavit of 15th of May 2024.
Like B.
I am told, my lord, it is running page 610 of my lord's brief.
747.
608.
747.
It starts at 608.
Yes.
610 is paragraph 7.
Further affidavit.
I am
filed
grateful.
on behalf of opposite party
I am
number
grateful.
3.
I am grateful.
747.
Clause paragraph 7, 610.
Yes.
We had said, my lords, that without prejudice to the above submissions, it is humbly submitted that the open number 3 is willing to allow other bidders, players in the country, as stated above, to participate in the present bid by deleting clause 23 Form S for the new players bidders by issuing appropriated notice. I'm sorry.
Yes.
Yes. My lords have that. So, para 7, my lords, we had said that we will allow others to participate. What my learned friend says is that others should include him also. My lord, I leave it to your lordships. I leave it to your lordships.
Very grateful to my dear.
And may I also say, my lords, that there was one submission which was being made by them, that why the state is so anxious that they should not get in. And therefore they were attributing malafide other things. Not that your lordships have seen, we have borrowed that clause from other tenders. So therefore those are far-fetched, no pleading, nothing. And I checked up, my lord. This petitioner has a record of litigation everywhere in the country. And I would only want, my lord, next round when they come up with this litigation, your lordships will kindly bear this in mind, because my last date is frozen by the government of India. My lord, I leave it at that. My lord, ultimately an officer of this court, more than the lawyer for a department.
So the learned Advocate General has been as gracious as ever. He's always very
No,
gracious.
I don't take cognizance of this because his seat was here yesterday. He couldn't have left us and gone.
I'm sorry. I'm sorry, my lord. Unfortunately, I was caught up.
There can
I'm
be
very
nobody
sorry.
more gracious than him, my lord.
Let us see what can be done.
My lord,
Very well.
yesterday
Deeply
I had a
grateful,
bad
very
time in the bar. People told me one day before the vacation, if you both argue till lunchtime, then what is left for us? because
No, but happens.
I'm grateful.
Deeply grateful for a very patient hearing, my lord. Very grateful to your lordships. Can't tell your lordships how grateful we are for the petitioners at least.
Lord, can we take the liberty of filing a small note of submissions tomorrow?
Let's do that. If
Yes.
you do it by
Next 2
tomorrow.
days, by tomorrow.
Mr. Mishra, you also may.
We'll do that. my lord. We'll do that. We'll do that.
From our side, we have given the convenience now.
The only observation
Yes.
that any decision taken in we are not saying anything.
My lord.
We are just observing that any decision shall be subject to final adjudication.
Right.
All right. We hope that we shall be delivering judgment on some day during the holidays.
My lord, we are not pushing your lordships for a judgment. Your lordship may take your time. There's no great hurry.
No, there is hurry because of that day.
Because that election is still on 4th.
But still,
Yes.
if it comes, then
My lord, we will maintain status quo as of now till that date, and status quo ante, because whatever your lordships have already said something.
So far as, if I can submit something, what I had tried to submit earlier is that so far as this clause 23 and Form S is concerned, the petitioner may not be concerned with that in this writ, because that's not the ground. And so far as the ground of rejection of the petitioner's bid, that I think we have made good with the clauses.
So, Mr. Mishra, prima facie, this is our tentative view. We don't know unless the last word is written in the judgment. We don't know what view we shall be taking. But prima facie, we are of the view that so far rejection is concerned, the petitioner's rejection, we find it difficult to interfere with that.
That your lordship.
At the same time, we find it impossible to sustain that 23 and Form S. So these are two things
that we get.
So, and then how shall we balance the interest, public interest, and the petitioner's interest and party's interest? That we will see.
Grateful.
Right. This is our tentative.
What I had submitted was that your lordships.
That's all one desire.
If your lordships can actually Form S and 23 cannot be accepted. But your lordships may in the background of this case, even if that is quashed or set aside, it may not have, I'm just submitting, it may not have a major impact on the present tender, because that's not the ground on which any of the parties.
We will see. We will
so
see,
maybe as a guiding light for future.
Because we are on a different plane altogether.
Of course.
So had it been a simple case of rejection of his, the matter would have been different.
Yes.
And again, had it been a simple case of putting to challenge that matter would have again been different. But here we have to answer both the questions and decide it.
We are all grateful to you.
So that is.
But grateful for your lordship, very patient
All right.
hearing.
Deeply grateful. Deeply grateful.
It is a result. Stop, it is made clear that.
I think there's an interim order earlier. Which is interim order. That will continue.
Interim order shall continue.
Great.
Most grateful, Lord.
Item number 5.
I have received complaints affidavit submitted by only one thing, my lord. Here after issuance of contempt notice, my lord, they have initiated 4 enforcement case and Tahsildar has submitted report on 16/5. I only pray that 4 proceeding may be targeted.
That cannot, we cannot direct contempt proceeding. No. Yes.
Item number 6.
So 6 says, for my instruction, there was a direction to dispose, he is already disposed of. I have given a copy to my honorable senior also notes.
My lords may kindly see the peculiarity of the case. Here, a sand quarry was put to auction. The rule is if
No,
somebody.
let us see the order. We cannot go into the merits of the.
No, I'm not going to merits. Your lordship, I kindly see, they say in the affidavit, these quarry matters have been transferred to the Department of Steel and Mines on 3/8/23. They have filed an affidavit on 5/10/23 before this honorable court, but nothing was mentioned there.
No, where is the order of this court?
Minutes, order minutes, I'm saying. In my contempt application, I have quoted. I filed the copy of the order at page 11.
So come to paragraph 3.
Let the petitioner give such a proposal to the tendering authority, who will consider the same and pass appropriate orders in accordance with law for grant of lease in respect of the sand quarry. I have given this proposal, but they did not do anything.
No, tendering, who will consider the same?
Then Tahsildar was the tendering authority.
So Tahsildar has whether has done anything or not?
No, now they have come up with an affidavit. This sand quarry matters have been transferred on 3/8/2023 to the Department of Steel and Mines.
Yes.
But I have given an affidavit on 3/10/23. They have filed an affidavit. They don't spell out about this.
So how will they comply with the order?
They have not complied.
How can they?
Number of whole difficulty in Millards
That is not the difficulty. The difficulty is.
Had they informed me earlier, I would have amended and implemented the Steel and Mines Authority. Though it has been transferred on 3/8/23, in the affidavit on 3/10, they don't spell out that also.
But that order cannot be complied with now. It's impossible. And whether any counter affidavit was filed in that case?
Yeah, additional affidavit was filed on 310. I have given that copy of the affidavit
Additional affidavit by whom?
by the collector, sub-collector. Nobody spells out during hearing also. It was never spelled out that it is not with the Tahsildar or the normal authority, it is steel and mines. They were never spelled out.
But whether Tahsildar can now comply with the order?
No, they cannot comply. But what the question is, whether the state is losing huge money. That is the whole difficulty. This sand quarry is a really a dangerous thing in this state. Sand is being exported.
Right. But whether those aspects can be looked into in a contempt hearing.
Whole difficulty means how they should have spelled out in the earlier affidavit, so I would not have implemented the state.
Right. It will give you liberty.
Obliged to not.
The writ petition filed by the petitioner was disposed of by this court by an order dated 11/12/2023, operative portion of which reads thus: 2, 3, 4. Stop. Next. And senior counsel appearing on behalf of the petitioner has submitted that the said order has not been complied with. Despite proposal having been made by the petitioner in terms of the said order. Stop. Next. It has been submitted by Mr. Samantrayal and AGA appearing on behalf of the contemner that the Tahsildar Arbanga has passed an order on 24/2024 in the light of this court's order dated 20, sorry. What is the date of the order? Dated 11/12/2023. Stop. A copy of the said order dated 24/2024 has been produced before us. Stop. From the said order, it transpires that when was this decision taken? 5/10.
3/8.
That. Where is the mention of that?
Yes, Lord. That second
That-
page of that order.
That.
In process 3/8/2020.
No, you transferred, but
Yes, Lord. That I'm saying. In process of the order of the thereafter is no longer in possession of to be considered as appropriate.
said order, it transpires
Inquiry has already
that-
been transferred to the Department of Steel and Mines on 3/8/2023. Right, R&D with the letter number. That is the last page of that order now.
that in the light of R&D dot M what is R&D?
That's revenue and disaster management.
Revenue. No, but how it is, where is the decision that now of this central government, Department of Steel and Mines, will take a decision.
That is not letter date 2/2023, letter number 17 dated 7 February of the
Steel and Mines of the same state of Odisha.
Yes.
Acha, you have this department.
Different department.
All right. That Tahsildar Darbhanga is no longer in a position to consider the petitioner's case as the appropriate authority is now the Department of Secretary, or who? Who is the Secretary, Department of Steel and Mines? And accordingly, the petitioner's papers have been transferred to the Department of Steel and Mines on 3/8/2023. To the Department of transfer to the Department of Steel and Mines, no. 3/8/2023. So, when senior counsel appearing on behalf of the petitioner has submitted that if the there was change in the tendering authority, it should have been brought to the notice of this court when the matter was taken up on 11/12/2023 and the order was passed. Stop. He submits that this court was not duly informed about the fact that Tahsildar was no more the tendering authority, which no more the tendering authority. Stop. Be that as it may, as the order of this court dated so cannot be complied with by the Tahsildar. Stop. In such view of the matter, the present contempt proceeding against Tahsildar cannot be maintained. Stop. We, however, observe that the order of this court dated so and so 11/12/2023 must be respected by the authority wherever the petitioner's matter is pending.
He himself says in the letter, so this order is communicated to the mining officer both for taking appropriate action in the said letter.
So therefore, we have said that wherever it is pending, they should respect. Stop. Otherwise, else it will have its own consequences. Ask him.
Yes, very
Item number 7.
This is second content, my lord. The order dated 26/3/2013 passed in WPC number 13 has not been complied with. The second contempt, the first contempt, by the order dated 26/3/2013, this honorable court was pleased to dispose of the writ application with the following direction.
You want us to initiate contempt proceeding for violation of an order passed on 26/3/2013?
My lord, that is the order passed by this honorable court. As for non-compliance of that order, one contempt application was filed. That is,
But this order was passed in 2013. What can be done?
and the first contempt was filed during the year 2013, which was also disposed of. Your lordship may kindly see page 14. That was disposed of during 2017.
And now,
And this contempt petition is pending since 2018, my lord. Because in the first contempt, this honorable court was pleased to direct to comply the order within a period of 3 months.
so what is this matter about?
This is all our employees working under the district and session judge Dhenkanal. They have challenged the gradation list of class 4 employees. So in the order
person
itself, it has been reflected.
Person must have been retired.
No, my lord, this person is still.
He was described at
Petition is
at
continuing.
about 50 years in the year 2018.
Yes.
What can be done? We are not inclined.
My lord, there are 39 employees, my lord. They have filed this case. My lord.
Petitioner alleges disobedience of an order of this court passed on 26/3/2013 in which case WPC number P427 of 2013. The said order reads as under. Full stop. The petitioners had filed contempt petition earlier, giving rise to CON TC number 1310 of 2013, which was disposed of with the following order, 17/8/2017. Full stop. The present contempt application came to be filed in 2018, whereafter it has been listed for the first time today. Full stop. Why even the representations are not disposed of? With with long passes of time, because of long passes of time from the first order which was passed on 2013, we are not inclined to proceed in the present matter. Contempt proceeding is dropped.
Item number 8.
I wrote on behalf of my senior Bijakam Parida, no instruction.
No instruction dropped.
Item 9.
Page 7 of Annex 1, my lord, is the order of this honorable court that has not been complied with. So this contempt against the Special Land Acquisition Officer Jagatsinghpur, that is at page 7, My lord, say direction was given to dispose of my representation that has not been done by the special land acquisition officer of the Java Assembly.
So when did you receive the instruction last?
Pardon, my lord, today also I have made a telephonic call to my client that has not been done by the authority.
Your representation is dated to 21/12/2015.
Yes, my lord.
You came here in 2017. Soon thereafter, the writ petition was disposed of.
Yes, my lord.
With a direction to consider your representation. Where is your representation?
Representation, my lord, Annex 3 of my rate petition. Annex 3 of my rate petition.
Writ petition,
Yes.
can you find out? So old matter is still.
My office shows that copy has not been issued the.
I am giving one extra.
Give him because it relates to some compensation.
Try to get it in relation to the copy of-
I'm giving one extra copy.
As requested on behalf of the state contemners. Is this matter on 2nd week of July?
Item number 10.
Please, Your Lordship. So may kindly pray for an adjournment after vacation, my lord, because I have to obtain some instruction. In the meantime, 4 years have passed.
Hmm?
In the meantime, 4 years have passed. My lord, writ petition is pending. Against an interim order, I have come before your lordship in a content petition. So I have to take some instruction what has happened in the case, my lord.
No. What is the order?
They have, yes, my lord. Page 7 starts. At page 10, my lord, the impugned order is there. The last part of the order is, in the interim, it is directed that for the time being, neither of the parties shall create any third party interest in respect of the disputed property. This is with regard to that acquisition of moat house, my lord, around the Lord Jagannath temple, my lord.
No, but this is of 2017.
Yes, my lord.
Why contempt now?
No, in 20 I have filed it.
Hmm?
Now I have to take some instruction
No.
because writ petition is pending.
Maybe writ petition is pending and pending. The writ petition is of 2017.
Yes.
The petitioner alleges disobedience of an interim order dated 10/10/2017, passed in WPC number 21054 of 2017. Stop. We are not inclined to proceed in the present contempt application for violation of.
Lordship, by Annex 2, they have taken action. That is why this contempt has been filed.
Annexure 2, it's a 2020.
20, my lord.
What have they done?
They have recorded the land in favor of Lord Jagannath. That is why. The direction was not to create any third party interest, but later on 20, came to know that it has the entire land record I have filed. Page 12, my lord.
So who had transferred the land? Tahsildar.
Collector.
There is no third party interested in theatre, nor there is transfer of land. They belong, they are the North belongs, a religious institution. They claim that land belongs to them. And the governor temple administration, they said that this land belongs to them. So writ application is pending. In the meantime, the Supreme Court in a decision of Sidamar said that OA Act is not applicable to the lands belonging to Lord Jagannath. And all about model land are to be settled with Lord Jagannath. In view of that judgment of the Supreme Court, the land has now been recorded in favor of the governor temple administration. No third party interest has been claimed. So between whether it belongs to governor temple or belongs to the trust, that will be decided. So the question of third party interest doesn't arise here.
So is he a third party? Is he a third? Who are you?
So he claims he is the second party. He claims that land.
He is mutt.
He is a mutt.
He is mutt.
He is mutt.
Where is the third party? Who is the third party?
Because that has been recorded in the name of, because the interim order was not to create, and during pendency of
Whether there is any third party?
that payment
All right. Interim order. Current counsel for the petitioner has submitted that the order dated 10/1/2020 passed by the Tahsildar Puri in Revenue Miscellaneous Case number 2 of 2022 amounts to creation of third party rights. Now, the said submission manifestly appears to be misconceived. So, no third party, it is an admitted fact that no third party right has been created by virtue of this order. The contempt proceeding stands dropped accordingly. Yeah.
Item 11.
Item 11. Item 11, my lords, I pray for some time. I want to file a reply to this affidavit, which is filed by stated flag D.
Item 11.
Yes, madam, where is the order?
My lords, the order which is,
No, where is the order passed by this court,
yes, my lord.
which has been violated?
My lords, that is at page 14 of the contempt application, my lords, Annex 1.
What is the direction?
My lords, the direction is, in a nutshell, the direction is at page 30, no, not 34.
30, yes, 30,
Yes.
31.
Yes, my lords, page 31. Paragraph 14, my lords. The state respondents are directed, they were directed to convene a review DPC for all the applicants for consideration of promotion to the post of Under Secretary with consequential benefits, etc. This matter had also gone up to the Honorable Supreme Court, my lords. And the Honorable Supreme Court had also confirmed the matter and also passed certain directions. What I'm aggrieved with.
No, if the Supreme Court has passed certain directions,
Yes, my
the
lord.
contempt will lie before the Supreme Court.
No, my lords, the
If
directions.
something is beyond what has been held by this court,
Yes, my lords.
then the contempt will lie before the Supreme Court because the order merges with the order of the Supreme Court.
My lords, my lords. No, my lords, the Honorable Supreme Court has confirmed the directions, the orders passed by the High Court. And certain clarifications have been issued.
Therefore,
Certain clarifications have been
therefore,
issued.
had there been no clarification in the order of the Supreme Court, had the Supreme Court just affirmed the order passed by this court, then the matter would have been different. Otherwise, the doctrine of merger will apply, contempt would lie before the Supreme Court.
My lords, if your lordship.
Still, yes, so
Yes,
this
just-
order has not been, why?
No,
Now they claim that they'll get still from higher commission.
No, my lords, I'll just place the matter in a nutshell. I will place the matter. What has happened is that pursuant to this order, now I am promoted to the post of Under Secretary with effect from
No,
2019.
madam, that is not the scope of contempt proceeding. Please come to this paragraph. The state respondents are directed to convene a review DPC for the applicants, whether this has been done or not.
This has been done. This has
And
been done.
other eligible officers for promotion to the cadre. This has been done or not?
This has been done, my lords.
As per provision under Rule 9080, this has been done or not?
Because there is the question, my lords. This has not been followed. That is what my prayer is. Why multiple applications have been filed in this?
Those directions
Yes, my lord.
have been substituted by Honorable Apex Court Judge.
My lords, the directions
With
like.
form of clarification.
Yes, my
The
lord.
virus part, their lordships have upheld.
Yes, my lord. Yes, my-
Virus, it is declared ultra vires by this court.
Yes, my lord.
To that extent, it was upheld.
Yes, my lord.
With regard to other directions are concerned,
Yes, my lord.
Honorable Apex Court has intervened and passed clarificatory directions.
Yes, my lord. At page 34, in
Those
fact.
directions, as my lord said, for the non-compliance of those, in case you are aggrieved.
No, my lords, I am actually not. That is what I'm trying to explain, my lords. I am not aggrieved by the non-compliance of the directions which are passed by the honorable, the clarifications which are passed. My only grievance is that subsequent to the 1980 rules, another 2008 amendment has taken place, which has reduced the period of 10 years of eligibility to the next post to 6 years.
You cannot press that in the present proceeding.
My lords, may I then pray for a short adjournment? Let me
No,
just.
you will give you liberty to.
My lords, I just pray for one small adjournment. I'll just take. I'll take instructions, my lords.
Prima facie, we are satisfied that no case of deliberate disobedience of this court's order is made out. Court's order dated, so and so is made out. The subsequent counsel for the petitioner, however, seeks short adjournment. So as requested, list this matter on first week.
Item 12.
Week number 4.
Grateful.
That's item number 12. May I pray also put it up on reopening, because the talk to the collector, he is busy in election duties. Only reopening he will comply also.
Reopening as requested. AGA.
Item 13.
Obliged. Item 13, my lord, similar medicine shop matters, my lord, sir.
Similar.
Status quo in those matters.
How many matters are there?
As per our office, mostly matters are over.
Like shops are more than the hospital. Shops are more than the beds.
My lords.
It seems.
Actually, my lords, in each DHH and CHC, everywhere there's a shop. So every district headquarter, then CHCs, they all have one. Then medical colleges have one private medical. So likewise, many shops have been affected.
In best of the medical colleges of the country, the shops are not there inside the premises.
Yes, I understand.
Go to AIMS, go to. It's not there.
However, my lords, in those small district headquarter hospitals.
In 2016, that policy decision was taken. That my lord will see.
I'm grateful.
there are some mistakes in some of the orders.
We have already informed not to take any action.
We will not.
That is already.
In case you find in any of the orders, the status quo order is absent due to some inadvertence. So
No, we have taken care of that.
because of this vacation, because
was
of-
here and the status quo, we have implemented.
so we found that in certain orders.
That's a mistake.
Yes.
We have it. Not to take any course.
We will see later after situation.
Deeply.
जोड़ा है ही नहीं सिद्र कर दूंगा जोड़ा तो ही भी चाहिए देखिए जोड़े अभी भी चाहिए ना सिद्र कर दूंगा कुछ
And the read petition, the petitioner has not challenged the government decision, rather they have paid to work out the government decision. Let's see for the moment, page 14.
You are seeking review of which order?
Order dated 18/3/2024.
What is the order?
My lord directed that the petitioner has questioned the decision of the state. But actually the petitioner has not challenged the decision. The petitioner has prayed to work out the government decision. Let's see for the moment, page 14, annexure 2. This
Just
is
a
the
minute, just a minute. Yes, what is your case?
Let's see for the moment, page 14, annexure 2. The 4/8/2022, government taken decision and directed for construction of a new RI circle in Badpur.
What do you want?
We wanted the construction of RI circle at Badpur.
Huh?
Construction of a revenue inspector office at Badpur. But the Tahsildar, he has deviated the government decision and shifted to an ashram of Badpur. That decision of the Tahsildar I have challenged. I have prayed in the read petition to direct the work out the government decision. After annexure 1, the decision of the government, tender notice was floated. Thereafter, the Tahsildar has taken the decision to shift the RI circle.
So what is the public interest?
Public for construction of a new RI circle at Badkul GP.
What is the public interest?
The people are suffering.
People of other area may also be suffering.
No, in their area also there are RI circle, but this is a new
You
GP.
we will not decide.
No, government has decided, and government decided construction of new RI circle at Badkul. The petitioner has paid to
We
work
are
out.
again asking, what is your interest? What is the public interest?
The public demanded for construction of RI circle at Badkul. Government allowed and sanctioned and created the new RI circle at Badkul. But the Tahsildar shifted that RI circle to another place. Thereafter,
Yes. Is it the fact?
One second, Mala. Thereafter, the petitioner made representation before the secretary by the annexure 4, and the government by the annexure 5 directed to the collector to inquire and submit the report.
So,
but the collector, when the not taken decision, the petitioner moved before this court and prayed to direct the authority to work out the government decision.
What is the public interest?
Public interest for construction of a new RI circle at Badkul GP.
He is interested that the RIs.
That we understand.
But the village where we are proposing to have that.
Oh, he says that the government had taken some decision, Tahsildar had modified that. This is what he wants to say.
I have taken instruction.
Seek instruction will. 2 weeks, sorry, 8 weeks. Yes.
Item 15.
Yeah.
My
Yes,
lordships.
Madam, what happened?
Lordships, I've analyzed the data which was submitted in the affidavit. My lord, there are two aspects to it. In fact, there are two issues. One is the statewide implementation of the RTE Act, and another is where the IA was filed that there are some students at hand who have been denied admission. My lord, first coming to the point where the students at hand, whether they can be given admission, in Bhubaneswar, there are 890 seats vacant across private schools. My lord, there are 63 students who were denied admission. And I have analyzed the data with respect to the schools, and they all fall. And these students can get admitted into other private schools which are within 5 to 10 kilometer radius from their homes. My lord, so in that case, if they continue denying admission to them, that is, we need to question, my lordship, that why is this being done? And even the same schools which have denied admission, they also have seats.
Next time, we will hear you only, because in the present public interest litigation, you have raised the issues of residents of Bhubaneswar. So the people of Odisha don't live in Bhubaneswar only. So you will have to raise the issues of the tribal children also, or from remote areas. How are they, whether they are getting the benefit of a Right to Education Act or not?
Definitely.
Otherwise, we cannot give preferential treatment to these children who live at least
in the city.
Yes.
Lordship, even coming to the second
examine, work out on that, the remote areas. Come to the court, we will see, we will take up
my lordship,
those aspects, not only for Bhubaneswar or Cuttack.
My lord, the data for the even across the state, my lordship, also, if I have analyzed the data, not even 50% of the seats have been filled up. There are 44,890 seats available, out of which only 21,649 students have taken admission. This is across the state. Lord, this act has not been implemented in a manner where all the students can take benefit of this.
We'll see, but see, we cannot sit in their place. We cannot do what they are required to do. We can just tell them, remind them. And at times, if required, we can issue directions also. But you will also have to come out with some,
my lordship,
something, not only for underprivileged. For how many children of living in slums they have been admitted at your initiative. Do something. We are there. Not even a single.
My lordship,
so these
that
private
requires
schools are not only meant for those parents who can go to the office of the director. This is also for those who cannot go, who don't want to go. They don't know
yes,
whether there is something or not. So you will have to go to them to tell them their rights. Then you will have to, that is public interest.
Education to parents.
Please do some more homework and then come. We will see. We are adjourning it. All right. And on the next day, we will see what have you done in the meanwhile. Go whether there are slum dwellers, some slum children in Bhubaneswar or in other areas or not. Go to them, meet them, tell people to, if you want, we can engage the Legal Services Authority also.
My lordship,
Plus, if you want in public interest to do something concrete, then you can proceed this way.
Yes,
all right.
Yes,
Otherwise, it is very easy to say that so many seats are vacant, so many students have not been admitted, and the persons are interested, they are not being admitted. We can see that also, but we will have to.
Parents associations also.
Parents, there are parents association, there are the people who are literate, but just see the plight of those children. And they are no less talented than any other child, you know. If you can do that, do that. Otherwise,
My lord, I will during the
Please do.
vacation
Vacation,
take up
do
this
something.
Lord, in the meanwhile, I may pray that at least for these students who have been denied, can they be given admission as per their choice? Because the list of vacancies are available. If these students can take
That
up a
will be-
choice.
That will be looked into by them. Now, today we don't want to pass any order, except that unless in fact, taking up the issues of these children only does not serve the real public interest. So I'll take up your matter only after you tell the court that you have been able to ensure admission of at least 100 children living in slums or other in some good schools. All right.
My lordship, I was engaged by
You
the
will-
petitioners, but now I have become proactive in
Yes,
this.
you will have to become. Right. So this is the time when you can work for the society.
It can be termed as pro bono.
We will see. This matter on. 27th of June.
Obliged.
Item number 16.
Let's file the application. Last order.
You will have. Appeal is not there. What is the progress?
But so far in her front, progress is substantial. If your lordship just looks at the photographs, notes, page 11 onwards. Page 11 onwards, my lord.
Yes.
Most of it is complied. And the photographs are there from page 15 onwards. The places have been cleaned. There was non-mentioning, if your lordship sees, my lord, page 15, there is a gate with a signboard, which was one of the objections.
Which page?
Page 15, my lords.
15.
Yes.
Yes.
So these are one of the things that we were required to do was have a proper gate with a signboard that your lordship will see at right-hand side.
Yes.
And all these places have now been cleaned. And the new building.
Yes.
And the new building is under construction that your lordship will see at page 17. And this is scheduled to get over by end of June.
Yes.
And the herb shops, etc., my lords, page 18, they have all been cleaned.
Yes.
And the children park, if your lordship sees, page 18 on the right-hand side, my lords.
Yes.
That is also there.
Yes.
And fencing is there at the next page.
But this is Utkal only.
Yes.
Utkal.
Yes, this is what was the complaint. And if your lordship sees page 20, my lord, what falls from your lordship, this is Cuttack. What my lords are saying is all over Odisha. That also she is compiling. If your lordships call it after the reopening, my lord, we will give your lordship, sir.
All right.
Yes.
So, how many balasrams are there? All of them are called Utkal Balasram.
17 in all.
17.
17.
So, some of them may be in good condition.
So most of them are in good condition. There are minor issues, particularly with respect to the staff, which we could not appoint because of the model code of conduct, my lord. We have issued the orders. As soon as the model code of conduct is withdrawn, those staff will be in position.
Regular appointment.
Yes. So, my lord, most cases it's outsourcing agencies, but we're not able to place the orders with the outsourcing agency because of the model code of conduct.
As the patron-in-chief of the Legal Services Authority,
yes,
I may be visiting one of these Utkal Bala.
Yes, yes. My lord, if your lordships would just tell her, let her know, she can also accompany.
Which in your opinion
is the best and the worst.
Is the worst. So you will have to tell us that condition of this Utkal Bala Ashram is not good. And then
correct.
That can be based.
Lord, this is not an adversarial litigation.
Yes, yes.
So we are all trying to improve.
Yes. Kind of
we have a young officer.
We make effort. Sometimes we succeed, sometimes we fail. But we must keep doing that.
Yes.
Yes, this is one aspect that will be seen later. But what about that child?
Well, that child on 12th of April 2024, my lords, was last seen in one hotel Gati Krishna at Kendrapada.
That we had taken note of.
And my lord, kindly see 17th April, he was with his father on Ram Navami at Mahanga. And he was spotted, 17th of April, he was with his father at Mahanga, Ram Navami day. And 20th April, he was in Cuttack bus stand. That CCTV footage we have found.
Yes.
So, my lord, the lordship may call it on reopening. By that time, hopefully it should have been done.
And do you have any information about any such child missing from any other?
My lord, I have said so in my affidavit, if your lordship sees, my lords. If my lords kindly turns to page 7, paragraph 8. She has tabulated from 2017, my lords.
Yes.
That it is humbly submitted, Utkala Balashrams are following the standard operating procedure issued by National Commission for so-and-so, as per the information received from the respective district child protection so-and-so. Since 2017 till date, 57 children, including the present case, that is 4.22% of the sanctioned strength of 1350 went missing. Out of the same, 52 children have already been rescued. So about five kids, including this boy, from all the Balashrams.
See the seriousness of the issue.
No, I quite appreciate. But then I had to tell this to your lordship.
Yes, seriousness of the issue is that we don't know what has been done so far for other 4 children. Whether any case instituted, whether any...
But FIRs have been filed. FIRs have been filed, but the fact remains that they have not been traced. So your lordship may call it after the vacation. I will come out with a more detailed affidavit.
Yes. This may turn into a very serious controversy.
No, I quite understand, my lord. I quite understand.
Who is, what have you done, madam, for those missing children?
Look, she actually, the police, she has filed an FIR from Alash. Police is...
Who is there?
Yes. Look, the commissioner was here last time, but today the CC has called him for a meeting.
Yes. What has been done? Do you have any idea?
Sir, with permission, sir. Sir, we have only one case of Utkal Mushroom that is under review by the Honorable Court, sir. We have formed an SIT also. And SIT including 5 more teams. And we have verified all the CCTV footage. And mostly it is in that he's working as a helper in...
No, this is regarding one child.
No, the other one is different police station.
Beyond my jurisdiction, my lord. It's beyond my jurisdiction.
So that
it is from other districts, my lord. It is not from my jurisdiction, my lord.
We are just coming back then.
Yes, Lordship.
Suo motu petition was instituted based on a report submitted by a report dated 24/4/2024, submitted by the Secretary Juvenile Justice Committee, High Court of Orissa. Stop. The report inter alia disclosed missing of a child from Utkal Balasram, Khapuria, Cuttack. Stop. Cuttack since 12/8/2023, soon after his admission on 10/8/2023. Stop. The child has yet not been located, despite the orders passed by this court on 7/5/2014 and 14/5/2014. Stop. We have been informed by London Advocate General that the police officials have obtained inputs about the presence of the child with his father on 17/4/2024 and at the Cuttack bus stand on 24/2024. Stop. The report of the Secretary Juvenile Justice Committee also disclosed the poor condition of Utkal Balasram, Cuttack. Stop. It was in that background, the Director of Women and Child Development Department was directed to look into the matter including the instances of children missing from other institutions, childcare institutions in the state of Odisha. Stop. A disturbing fact has emerged from the affidavit which has been filed today shown by the Director ICDS.
Paragraph 8. Paragraph 8.
Paragraph 8.
Yes.
From which it transpires from paragraph 8 of the said counter affidavit, it transpires that there are 5 children who are missing from various various Utkal Balasams in the estate of a shop. Though it has been stated that 57 children, including the child missing from Utkal Balasram, Cuttack, were found missing from the institutions, 52 have already been rescued. So stop. Next. Certain averments have been made in the counter affidavit as regards the improvements done in the condition and upkeep of Utkal Balashram Noapada Cuttack. So stop. We shall consider the said affidavit on the next date of hearing. Stop. Next. For the present, we direct the who heads DGP or Commissioner? DGP. DGP, the Director General of Police, to personally monitor cases of all missing children from various Utkal Balasams in the state of Odisha. Stop. The DGP shall be required to file an affidavit on the next day stating the steps taken to rescue the missing children with reference to with particular reference to the investigations undertaken by the police on the FIRs registered in that regard. Stop. Since when are they missing, madam? Do you have any?
One child has been missing since 2017, another in 2018, one from 21, Milord, and one from 2023, that is the present case of the PIA, and another from February 2024.
Please do something.
Well, I will speak to the DG myself.
Let's this case on second week, that's 25th of June. To be taken up within first 5 cases. Within first 5 cases. Stop. The court would expect the Director of Social Welfare to file an additional affidavit disclosing the status of other Balasrams in the state of Odisha. Utkal Balasrams in the state of Odisha. Whether JJBs are not functioning, JD, you don't have the members.
Milord, JGBs, all of them are not, it's not that all of them are not functioning, and in the last meeting.
No, the members are not there. We have not appointed members.
I'll look into the case-to-case status, Milord. I don't have it with me right now.
You'll have to see. In fact, when I had the occasion to examine the when your Juvenile Justice Monitoring Committee, through Juvenile Justice Monitoring Committee, we have been informed that the members have not been appointed. And if the members are not appointed, JJBs cannot function.
Sir, I'll definitely look into it.
And if the JJB cannot function, then the entire juvenile justice administration. Yes, the whole purpose of the act is defeated. Please ensure we don't create a situation where we take up another suo motu PIL. All right. Some issue relating to the constitution of selection committee. The chairman had resigned also for selection of second. You require a selection committee, no, for appointment of members.
Milord,
Please examine.
I'll look into the exact procedure.
Please examine. Well, grateful. Affidavit taken out. What has happened?
17.
Yes, sir. The batch of matters, your lordships can take it conveniently after the vacation.
Yes, sir.
So this will take some time because some viruses are also challenged as well as some notifications.
Then
So,
state has to run.
my lord?
State has to run by your satisfying the demands.
So one of the sub-item, WPC number 10584 of 2024, my lord. Your lordship has specifically fixed the date to 2nd of July, my lord. I am giving the order to your lordship, my lord. This is also there in this batch of writ petition, my lord. Specific date, your lordship.
168A.
Yes, my lord. Your lordship has also informed all council in the meantime to complete the readings, my lord. That order I am giving to your lordship. This item is also there today, my lords, in this batch.
So all the matters should come on 2nd of July.
Yes.
My lord,
Cases already we have filed counter all these cases.
we have also in the second sub-item, my lord, in the second item, the interim order could not be extended on one of the dates. So when we mentioned your lordships, like when the matter was before the coordinate bench, the bench said that we have to file a miscase for extension, so that we have filed. So that the interim order can be extended.
Which case?
In the second sub-item, that is WPC
Engine.
number 1728 of 2024.
Engine Global.
Engine Global. And that IA is at flag B, my lords.
4144.
4144.
Where is that? 17.
It's
Oh, no.
second item, my lord.
Second sub-item.
Yes, 1728 of 2024.
IA number 4144 of 2024.
The first interim order was passed on 30th of January 2024.
The earlier, comma by an order dated 5/3/2024.
Yes.
2024 passed in IA number 1434 of 2024. The opposite parties were asked not to initiate any coercive step against the petitioner pursuant to the impugned order of adjudication without the leave of the court. So this application has been filed for extension of the
Interim order passed on 30th of January 2024, my lord. In this case, it is 30th of January.
30th of January.
Yes.
30th of January.
That can all be extended till the next day.
The interim order dated 31/2024 stands extended with the next date. I number so and so stands disposed of.
Yes.
My lords, may I respectfully mention?
Please, please.
On 5th, 7th, and 8th minutes. The interim order was till next date means till today minutes. I am giving a slip minute, it can be extended till next date minutes.
Interim orders.
I am passing on a slip minutes, mentioning the numbers.
My lords, may I mention? My lords, I am representing sub-item 1 and 10 in the batch. My lords, in this, my lords may please direct the opposite side to file counters in our petitions. This is for Tata projects, sub-item 1 and sub-item 10. My lords, we have not been served the counters in the matter.
First item, my lord, this accountant general, there is implemented opinion number 5. Depot director CRA is coming under the principal CAT. CAG is there. So if their counter is filed, look at the lordship is noticed, then only counter question is coming. Yes,
no, no, you don't.
First item, this is 11324 of 2024.
First and sub-item.
That,
you don't represent CAG.
no, CAG, there, CAG we are repeating, but they have a local panel also. Lordship may issue notice. I wrote a letter. Either they prefer to file counter in the.
What do you want?
My lords, please direct them to file counter in the matter and serve it to us because we have not been served the counter in sub-item 1 and 10.
We don't have file.
That. In the meanwhile, the parties have filed their counter affidavits.
Yes.
As and when so advised. So you accept notice on behalf of CAG or not?
Let's make director. We used to notice and
okay. So, also has accepted notice on behalf of
book number 5.
Opposite
1 and 5.
1 and 10, my lords.
And 5 in WPC 1, first case.
First case. That is 11324 2024.
Why CAG is a party?
He is a deputy director, CRA, office of the principal accountant is implemented a party claiming there in that they don't have a power to audit. Basing on that, the GST has imposed the SSD tax.
They are given a report.
They are given a report after auditing. Their stand is that this accountant don't have a power against the private party and they didn't have a power to audit this end. Basing on which the GST department assessed this end.
All right.
In item number, in the first item number, I am appearing for the department, my lord. That is 2, 3, and 4. I'll file my counter affidavit.
Which department?
Central GST, my lord. Central GST and Central GST and Central Excess.
So file it.
I'll file it.
That's for sub-item 10 as well, my
I'm
lords.
requesting my lauded friend, Mr. Tagi, to give me a copy of the.
Give him.
Your lordship may direct in all these cases to pleadings to be completed by the next date so that these matters can be heard. Your lordship, in some of the matters we have filed the counter so far as the state GST is concerned, and also pleadings have been completed so far as the state GST they have filed the rejoint. Your lordship. Your lordship.
There is already a direction.
Your lordship.
In this case on 7/5/2024,
My
Mr.
lord.
Tangri,
Yes, my lords.
you are required to furnish copies of writ petition. The required
We
number
have
of
furnished, my lords. We have furnished our AOR.
served and learned counsels. All
My lords, pursuant to the directions last time, we have supplied the copies through my AOR.
Huh? What are you saying?
My lords, we have supplied the copies of writ petition to the opposite parties through our AOR pursuant to my lord's direction last time.
Have you supplied or you are
We
yet
have
to supply?
supplied. My lords, we have supplied.
Think you have supplied.
Who is your local counsel here?
My lords, Rahul should be there in the court. Rahul Ray.
Have you given him copy of the petition?
Lordship, copy. Different counsel are appearing for different parties. Now he's alleging, not
Lordship,
alleging.
after the order,
He has not received.
We shall supply another copy then, Lordship. Another copy, we'll supply another copy by the end of the day.
You may dismiss your case on that ground.
Lordship, I apologize for that.
Only let the parties in the meanwhile exchange the pleadings. From it is expected that on the next date, then counsel for the parties have addressed the cases on merits without seeking further action.
Obliged, obliged.
Obliged, Your Lordship.
Obliged, my lords.
Second.
Item 18. My lord, due to some personal difficulty, my lord, this matter taken up after vacation, my lord.
As requested, what is this PIL?
No, my lord.
Oh. As requested. July 3rd week.
Item 19.
May I please, Your Lordship? And here this is PIL, my lord. Concerning Your Lordship, may I see Annexure 1, the government has brought the scheme for assistance of the indigent and distressed artists of the state. And that scheme was introduced in the year 2018.
So what do you want?
But that has not been implemented in spite of the finding of eligibility. I have given Annexure 3 series. It starts from page 25 throughout the district. And Your Lordship will find the vacancy position at page 24. So far the Baleshwar is concerned, it is vacancy position is 1091 beneficiaries are yet to receive their assistance.
Yes. What is for the state?
19.
Artists are to get some
I'm sorry, also.
benefit from the government copy.
They want your own scheme to be implemented.
No, so I may request because the office shows that no copies. I will request my friend to give a copy so that I can.
Servo copy.
Yes, additional copy I can give.
Yes.
This notice of the opposite parties. Let copies of the writ application. Violent counsel for the petitioner on Mr. Samatray, London AG. Who will you will appear?
No, so my friend will appear.
Yeah. By today.
Yes, Your Lordship, by end of the day.
Fourth of the day. What is the matter in July? So as to enable State Council to file counter affidavit.
This is Mukhyamantri Kolakar Sahayata.
So this is your own scheme. That has, they want that should be implemented. That's all.
Item number 20.
May I please, Your Lordship?
In this case, my lord, the present petitioner prayed to extend the lease period due to the stay order of the Honorable Green Tribunal, and petitioner could not able to operate the Khanjamal stone quarry, stone quarry number 59 since 2021 till today. Thereafter, several approaches of the petitioner, my lord, to issue the EC, my lord. Your Lordship kindly peruse Annexure 1, running page 18, my lord. did executed the quarry, my lord. The
So what
five-
happened to the interim order passed by the tribunal?
My lord, tribunal pleased this order, my lord. I have quoted in paragraph 7 in page 19, way number 17, the directed for the Great Tribunal Director operate the but known fully the operation, the executive agreement allow the operation to query. Tribunal was please allow the operation.
No, where are you reading?
Annex, my lord, paragraph 7, running page 6, my lord, of the writ petition, my lord.
Yes.
And order dated 22/11/2017, MA number so and so. The MA has been filed seeking the direction upon the state government to permit 63 stone quarries unit operation, Mohuman and Khanjamal village view to the fact no state due to not fall within the prohibition area, eco-sensitive zones of the Kuldia wildlife.
The quarrying was stopped because of an interim order passed by the tribunal.
Thereafter, not extension, my lord, but Honorable Court also directed on this other case, my lord, in this same area, extension of the lease agreement, my lord. Your lordship kindly bear.
No, what happened to the order passed by the tribunal?
Now, thereafter, my lord, no EC has been issued in favor of us, my lord.
What is EC?
Environment clearance certificate, my lord. Now, other quarry also operated now after passing the Green Tribunal order. My lord, what happened, my lord? After passing the
Sanjay Das.
Yes, my lord.
My lord's query is what happened to NGT?
My lord, now NGT already given the order, my lord, for the operation of the stone.
Where is that order?
My lord?
Where is that order passed by the NGT?
Order passed on dated 22/11/2017. I have quoted, my lord.
What is there?
My lord, page number 6, my lord. Last paragraph.
Yes.
The MA has been filed seeking for the direction upon the state government to permit 63 stone quarries unit to operate in Mohuman and Khanjamal village in view of the fact that they do not fall within the prohibition area of eco-sensitive zone of the Kuldia wildlife sensitive since notification by the MDBH filed notification number 9/8/2017. It is case the application of despite separation direction of the tribunal that the prohibition or issue order by the on 17/3/2017 would only sustain until the notification.
What is the
of
order? We have not been able to understand.
Thereafter, my lord, now all the stone quarries already operated now, but in the present petitioner's query, not operated due to the issue of and I have quoted, not filed, my lord. That is already disposed of, my lord. Green Tribunal disposed of the matter, my lord.
Where is the disposal order?
My lord.
Where is the disposal order?
But other cases, I have already given the certified copy of the order, quoted all the things, my lord. In same matter, extension of the lease period. Due to the stay order of the tribunal, that entire lease period already gone 2 years, 6 months are not operated. Now, our lease period is only 3 months per month. Only the last date of
Order is not there.
Yes, madam.
NGT order is not.
NGT
Where is the NGT order?
Order next.
See, we cannot follow an order.
Yes, madam.
Without understanding the order.
Yes. My lord, what happened, my lord? I will
What
produce, my
happened?
lord.
Nothing can be seen from this.
No, my lord, I will produce, my lord.
Mr. Sanjay Das.
Yes, madam.
Even if we go by this,
Yes, madam.
para 7 says that stone query number 46.
Yes, madam.
Your para number 5 of your brief.
Yes, 59.
59.
Yes.
So how can you say that this matter is comparable to this?
Because in this order, total 63 unit of stone quarry stopped
File affidavit. We will see.
due to
File
the,
your affidavit.
hereby file the order, my lord.
Huh?
But whatever in same Mauja, my lord, your lordship kindly peruse the Khanjamal. That is a Khanjamal area. Khanjamal. Khanjamal. Mauman and Khanjamal. Someone order.
And you also produce that NGT order of stay was operating in respect of 59.
Yes. Ours, yes, my lord, I will produce.
46.
My lord, same area, Khanjamal.
Maybe same area,
Yes, my lord.
but the demarcation is different.
Yes, my lord. Because in our, your lordship kindly peruse our agreement. Mauja Khanjamal, Khata number 144, plot 263.
We have not been able to convey to you.
Yes, my lord.
We wanted to know that where is the interim order restraining you from carrying the query operations? One. And where is the order of the NGT which vacated the interim order?
Yes, my lord.
Two. You don't have that.
Yes, my lord. I will produce, my lord.
You will produce the new.
Because in other case, my lord, what happened, my lord? Not in my case, that is total 63 units. All stopped after the tribunal order. Now the tribunal already disposed of this matter.
We cannot decide case on the basis of what is there in your mind.
Yes, my lord.
All right.
Yes,
we
ma'am.
decide cases on the basis of what is there on record.
Yes, my lord.
So
Subsequently, Honorable High Court directed another stone quarry their extension the lease period because due to the stop or prohibition order of the tribunal, some of the quarry not operated, and their period is 5 years.
Don't waste court's time anymore. This matter as requested on behalf of the petitioner. This matter on July 2nd week, so as to enable him to file an additional affidavit bringing on record the interim order said to have been passed by the NGT, because of which the petitioner could not carry out, could not carry the querying operations despite there being lease in its favor. So the petitioner shall be under obligation to bring on record the order passed by NGT culminating the whereby the proceeding before the tribunal stood culminated. Yes.
In the meantime, not to disturb my lord, because
we don't know anything.
Yes.
21.
My representation also pending, my lord.
Your representation will not do nothing.
Yes, sir.
Item 21.
Fix up the date, my lord. Otherwise,
We have fixed the date.
In which date, my lord?
We have fixed.
Item
You will
21.
get the order, you will get that.
Yes, ma'am.
May I
Yes.
small prayer is that the OPs may be directed to dispose of my representations under Annexure 7 and 8.
What do you want?
My prayer is only to direct the opposite party number 1 to dispose of my representations under Annexure 7 and 8. Except, actually, petitioner is a society, registered under the Society Registration Act. The society has established a college since 83-84. It was running, but the last principal was retired from service. He has kept the login ID and password issued by the AICT and BPUT, for which we are unable to communicate with the authorities. That's we have, for that reason we have submitted representations repeatedly, 7, 8, and 9. But till that, though initially AICT created a standing complaint security scrutiny committee.
So how is this a public interest litigation?
No, sir, it's not a public interest.
Not a public interest litigation. Okay. So who are you?
Yes, I am the society who has established the college.
You are the society. What do you want?
I want my representations under Annexure 7.
No, that we will not do. The representation will not direct for disposal. What do you want?
Sorry, I couldn't get.
What do you want other than that? Representation, what shall be done if your
Maybe the AICT may be directed to cause an inquiry and issue login ID and password.
AICT is an inquiring authority.
No, he is the controlling authority.
Controlling of what?
The college. Controlling authority of the college.
All right, this society, what does this society want?
Society wants the login ID and password.
Login ID has been
issued by the AICT.
Huh?
AICT issues login ID and password for each and every college under it. That login ID and password has been held up by the ex-principal.
Ex-principal. So that is a dispute between you and the ex-principal.
There is a complaint against with regard to fraudulent documents.
Yes, of course. Yes, submitted many fraud documents before the AICT. That's why we have repeatedly submitting representations. They have also created a standing complaint scrutiny committee.
Petitioner is a society registered under the Society Registration Act. Society Registration Act. Full stop. It runs an institution in the name of Regional College of Management,
Bhubaneswar.
Bhubaneswar. Full stop. The petitioner has filed the present writ application seeking direction to the AICT full formally to dispose of a representation which the petitioner has filed for making available the login ID
and password
which was available to the principal of the said college.
Ex-principal.
To the principal of the said college, which, who is not presently the principal. Full stop. Next. On the pleadings, on perusal of the pleadings on record, it is apparent that it's a dispute between the society and the principal of the college, who, according to the petitioner, is no more the principal, and withholding login ID and password which was provided by the AICT. Full stop. Considering the nature of private dispute between the petitioner and the opposite party member who is ex-principal.
No, I have not made any part.
Very good. Considering the nature of dispute, particularly when the so-called ex-principal of the college has not been implicated as party, as an opposite party in the present writ application, this writ application is dismissed.
Item 22.
The petitioner shall be at liberty to take recourse to appropriate provision of law before appropriate forum.
May I
Yes.
please, your lordship,
22.
in this case, the petitioner is a successful bidder for the settlement of sand source, and the source has been settled as per intimation at page 25, my lord. After settlement of the source, the required documents and formalities has been complied by the petitioner, and the lease agreement has been executed, which at page 43, my lord. After execution of the lease, there was a joint verification by the mining authority and the revenue authority. And during joint verification, the mining authority and the revenue authority found the surface which has been leased out in my favor, that is a waterlogged and this is not, there is no less sands available. Therefore, surface map is required to be changed. The suggestion has been given by the authority to the Tahsildar to submit a fresh surface map. And thereafter, under Annexure 15, my lord, Tahsildar, after making due inquiry, submitted a surface map to the authority for approval. And that application, the changed surface map at page 90, map is at page 92, is under consideration for approval by the mining authority. Though 6 months, 7 months has been passed, no decision has been taken. I could not operate the source and the revised plan could not be approved. Therefore, we have the present bidder petitioner before your lordship.
Thank you.
8 weeks. In the meanwhile, consider.
Yes, if it is.
Issue notice, accept notice. You have served copy.
I have
Yes,
served.
sir.
8 weeks time is allowed for the state opposite parties to file, for the opposite parties to file counter affidavit. So it is expected that in the meanwhile, it will be open for the opposite parties to consider the petitioner's grievance raised in the present writ application.
Item 23.
I may read your lordships. Your lordship, I would like to draw your lordship's attention to Annexure 2, my lord. That is a circular of the government with regard to transfer policy matters. Lordship may kindly have a glance.
What do you want? What do you want?
I want my representation at Annexure 3 to be disposed of.
Very difficult.
This is my sole bit. Matters. Annexure
difficult.
3 minutes, page 11 minutes. That can be disposed of because that can be disposed of by the OP number 2, my lord.
So what representation?
Representation with regard to transfer of the OP number 4, he has continued in a post for more than 6 years by that. So the policy of the government says in normal circumstances, one person is to remain in a post for 3 years, and in special circumstances can be extended to 6 years. But here is a case, since the OP number 4 has been continuing in her post,
we intend to impose cost. We intend to impose cost. This public investigation has been filed.
Merits may be kindly permitted merits.
Never do it. It's a service matter. Service matters cannot be the subject matter of public interest litigation.
I may be permitted to withdraw.
Counsel for the petitioner, after some argument, seeks permission to withdraw this writ application, which is accordingly dismissed as withdrawn. Yes.
Item number 24.
The complaints evidence not yet filed.
Except one that is contempt number 5623. In all cases, SLP filed by the state has been dismissed. Thereafter, a proposal has been sent to the finance department for release of the amount for not disbursal. So, your lordship may fix all the matter except 5623 or 23. After the holidays, in the meantime, we will pay the amount.
And what about 5623?
That is SLP is pending. SLP by dying number 55551 or 24 is pending. So, lordship also adjourn this matter because same maybe the fate of this SLP because all SLPs except this have been dismissed by the.
All of them relate to the same
department and benefit also same. But other SLPs have been dismissed. This SLP has not yet been taken up by the Honorable Supreme.
That is too technical.
No, I only pray you will also call it all these matters after the holidays. We will comply the order.
As requested on behalf of the contemners, by way of indulgence, these matters are adjourned to first week of July. Yes.
Item 25.
26 also.
I may be pardoned, my lord. I am in VC at Bhubaneswar.
Just a minute.
24, 25 is the same.
No, 25 is different, 26 same.
26. Yes, 25.
My lord, Annexure 1 order has not yet been implemented. This is regarding payment of retainer fee and some pending bills of the petitioner with the opposite party. Annexure 1 order, page 10.
The petitioner is an advocate.
My lord.
Can he file an application for direction of payment of bills? Yes. Who is for the cooperative society? Cooperative Federation, cooperative.
Odisha Consumer Cooperative Federation Limited.
After this order was passed, I also filed an application for initiation of contempt proceeding. That was also disposed of in order annexure 2 at page 11. Still then, no payment has been made, nor I have been intimated regarding how to be paid, when to be paid.
But this is not done. The advocates don't file a petition for payment of their bills.
My lord.
It's a notice. Yes.
Item 27.
Lordship's order has been produced. I've given a copy to my friend.
Compared with.
Lordship, main pre-lordship, petitioner may be granted liberty if it.
It goes without saying that the petitioner shall have the liberty to question the correctness of the order which has been passed while complying with this court's order dated so and so. So non-compliance.
Item
Yes.
number 28.
Let's say item number 28. Because some time is required because pursuant to direction of the Honorable Court, the Tahsildar has not yet disposed of this miscase number 26/2015, which has been directed to be reheard. So Lordship may call it after the holidays, after disposal only the order can be complied with.
Only one indulgence. My friend may take instruction, but the land upon which the order has to be carried out, and there is a specific direction by this honorable court till the process is complete, status quo order be maintained. What I have annexed also the documents that some construction has already started. In fact, a house also in the meantime constructed. A year elapsed in between. Instead of carrying out the order, they are allowing to construct. That my friend may take instruction. How could
that land is yours?
It is a communal land. This honorable court directed till and until the communal use is reinstated, the land should not be used for any other purposes. Paragraph 10 and 11, if your lordship.
So we'll see later.
If the construction will go on, my lord, because it's a smasan, that is what is my predicament.
That can be demolished.
But
some construction is being done, can be demolished.
That is what is my duty to bring your lordship attention.
See, they may decide to go to jail also. They may, instead of complying with the court's order, they may decide to violate it.
Yes, my lord. The encroachers, further encroachment is also being. They are
will
not.
See every year.
As your lordship is.
As requested. On behalf of the contenders, this matter on July 2nd week.
As your lordship is. From 29.
So, Lordship may call it after the, so elections are over, he has requested.
Item 30. Lordship, the second contempt, Lordship, till that the compliance period is not received, Lordship. Compliance affidavit is not received.
Compliance.
Order has been passed.
Lordship.
Compliance. Want to challenge that order?
I have not just now received this.
What is?
Taken
up from any other thing.
Yeah, there was a direction by the Supreme Court to the Energy Department to dispose of the representation of the petitioner. There was a case that the
No, but what happened? What is the decision?
decision is that a vigilance case has already been instituted and it's going on against the person against whom allegations were made.
Item 31.
31, my lord. Last occasional lordship kindly see the order dated 6/5/2024. On that day, my lord senior has produced a letter, that is letter dated 6/5/24, indicating therein the order should be complied with within 2 weeks. Thereafter, your lordship granted, put up on 17. On 17 also, they have not complied.
Lordship may take it up to 2 o'clock because on 17 I had talked to him. He had said that order shall be completed. The Lordship may take it out 2 o'clock.
2. At 2.
Item 32.
Now, 32 order has been complied with. I am giving the compliance affidavit in court, my lords. Out of 7 persons, 5 persons have been found to be eligible to get the benefit. Accordingly, 91 lakhs has already been released. 2 persons have not been found eligible because they are not appointed prior to the appointed date.
After vacation, I'll take instruction.
No.
I have received the compliance report.
We are giving you liberty to challenge.
Right.
Compliance affidavit has been filed to demonstrate that the court's order dated so and so, past and so has been complied with. Stop. In such view of the matter, the present condition is dropped. Stop. It goes without saying that the petitioner shall be at liberty to question the petitioners.
Well, 2 petitioners.
And so shall be at liberty to question the correctness of the decision taken by whom?
The director secondary education.
Director secondary education. And if agreed.
Higher education.
Higher education. If agreed, before appropriate forum in accordance with law.
Item 33.
My lord, order compliant. Compliant.
Thank you.
34 also.
34 also.
Item number 35.
Government को instruction to comply.
Yes, sir. I will give a copy. My friend, order has been complied. The decision has been taken on the representation filed by emails.
My sole grievance is to pay my dues, which is pending with the government. It has not been paid. Liberty may be given to challenge the same.
Goes without saying that the petitioner shall have liberty to question the correctness of the decision taken pursuant to the court's order dated. Taken question the decision taken while complying with this court's order dated such.
Item number 36.
My lord, last date, honorable court directed for instruction.
Complied with.
Yes, I've given a copy of the order for the representation.
My lord, complied and this copy, this order, my lord, as provided annexure 1, my lord, the petitioner filed the chart as per order of this honorable court in writ petition. But law is well settled there. What received and what not received, detailed chart is mentioned in detailed chart, my lord, but the opposite party contempt, my lord,
The order,
not complied, my lord.
What is the order?
Order, my lord, your lordship, may kindly see Annexure 2, this is the order of Honorable High Court. Paragraph 2, my lord, it is 2. Yes.
You
It is
were given
according to
liberty also.
order that each of the person mentioned in the chart submitted by the petitioner.
Now, please come to the last sentence of paragraph 2.
My Bolangiri, it will be open to such individual to seek appropriate remedy in accordance with law. All right, my lord, but the petitioners harassed manner and file
Mr. Seth.
repeatedly,
Mr. Seth.
repeatedly read petition
Mr.
before this
Seth.
honorable court.
Mr. Seth,
Man.
we are in contempt jurisdiction.
And 2012, they have received the amount. Now they claim higher amount on the basis of 16 notifications.
Not higher, what law says the petitioner demand.
What law says we cannot decide in contempt jurisdiction.
Man.
Compared.
Item 37.
Item 37, if I may please your lordship. Yes. Order which has not been complied with is under Annexure 1, your lordship, starting from page 11, wherein the present petitioners were before this court with regards to the non-consideration of his transfer application and imposition of penalty. While this honorable court considered the matter, in page 14, para 5, clear finding has been given that the authority cannot impose penalty, your lordship. Second part of the para 5. We are clear in our mind that clause 19 in the regulation do not provide authority for imposition of penalty. That finding, your lordship, in Annexure 2, the order under challenge, in page 7, page 18, your lordship, they have again imposed the penalty on the present petition.
What is the order?
The order, your lordship, that that IDCO cannot impose penalty and my application may be considered afresh with regards to the amount that I have to pay for transfer of the.
It's commerce, we cannot do it. Notice.
Notice has to go.
Notice.
Item 38.
Much opposed.
May I please your lordships? This contempt application has been filed by the petitioner for non-compliance of the order dated 25/9/2023, passed by this honorable court in writ appeal number 679 of 2003 in a common judgment, my lord. Till date, my lord, they are not considering, my lord.
It's Bindu Sagar, my lordships have disposed of all the cases because
Yes, my lord,
it
yes,
has
sir.
gone to Supreme Court.
But my petitioner has not.
Lordship may look at the order, covered order Bindu Sagar, so it can be disposed of on that line. I will take Supreme Court.
The matter has gone to Supreme Court.
That is not in the knowledge of the petitioner, my lord.
But we cannot do, we know.
My lord, in this department, my lord, that is soil conservation and watersheds
pending.
department, my lord, this only petitioner, my lord.
Madam, the matter is pending before the Supreme Court. Let us see your order. The second contempt application has been filed for disobedience of this court's order dated 25/9/2023, passed in WA number 679 of 2023. in the light of this court's order in WA number, this court's common order passed in WA number 810 of 2021, bracketed State of Odisha versus Bindu Sagar Samudra. Stop. It is an admitted fact that the decision in case of Bindu Sagar bracketed Supra is under challenge before the Supreme Court. Stop. Contempt. All right, not now. Once the matter is decided by Supreme Court, you can.
It is already 9 months, my lord, but in the writ of, my lord, the order says passed to comply the order within 4 months. It is already 9 months, my lord.
But this is the order which has been passed in other cases also.
Item 39. In item 39, pursuant to lordship direction, I have taken instruction from the Home Department. Home Department has requested the learned district and session judge Sundargarh to look into the matter because Home Department says Home Department is not the appropriate authority to sanction the allowances, that is house rent, fixed medical allowances, library allowances, sumptuary allowances, newspaper and magazine allowance, and conveyance allowance. So now Lordship may grant me some time. I will take up the matter with the learned's district judge. Who will pay that? I will find out, my lord.
Lord, this is the matter regarding wherein there is a non-compliance of this honorable court's order to pay the allowances of a retired learned district judge. And a representation has been made, which is at page 12. The Lordship on last occasion has directed the state authorities to find out who is to pay the amount.
The Home Department says now I will talk to the learned district judge.
It was required to be paid by the district judge himself. These are local. As requested on behalf of the contemners, this matter on July 3rd week. There is no representation on behalf of the petitioner. Stop. The office note suggests that requisitions were also not filed. Requisites were also not filed for issuance of notice upon the opposite parties. Stop. This contempt proceeding. Contempt proceeding stands dismissed for default accordingly.
Item 41. My lord, the pension and gratuity all have been sanctioned, communicated to the opposite party, but because of during this election tenure that could not have been released, but that will be released very soon. So I have communicated him. This can be listed after the vacation so that he will get the money. There's no difficulty, and this matter can be restored back to the for hearing.
Restored.
CMPL number 799 of 2022, my lord.
So this is for restoration.
My lord?
Is this for restoration?
Yes, my lord.
Is for restoration.
At the time of hearing, your lordship directed that the amount is to be released.
All right. We'll take up this later. As requested on behalf of the petitioner, list this matter on July 3rd week.
My lords?
July 3rd week.
Yes.
On the reopening the matter. In the meantime, they'll make payment.
Yes, that is already communicated. They have been communicated.
Let us see what happens that day.
Mr. Mahanti, that is the condition. Unless
Yes, that-
you get the money, it will be refunded.
And they have been communicated, sir.
'96 shall depend on the context in which the same has been used, and it may have a different connotation than as defined in section 2(1)(e) of the Act. 2. Applying the rule of contextual interpretation as permitted by the Act itself in its definition clause under section 2(1) of the term court contained in section 29A(4) and section 29A(5) of the Act has to be given a contextual and purposive interpretation, and in the case of domestic arbitration shall mean the High Court. The decisions of this court in the cases of KCS Private Limited and Lila Aditya Dev do not lay down the correct law on that point of interpretation of the word court contained in section 29A(4) and section 29A(5) of the Act. The cases may now be placed before the assigned single bench for disposal.
I agree. The judgment shall be uploaded tomorrow.
Deeply.
Okay.
Election commission has given permission, and consequently CEO has also given permission sent to the concerned department.
This is something very good.
Excellent. Very promptly this, because
London Council representing the Election Commission of India has produced before us communication dated 21/5/2024 issued by the Election Commission of India addressed to the Chief Electoral Officer, Odisha, in relation to the proposal for relaxation of proposal to the Election Commission of India for relaxation of Model Code of Conduct in relation to opening, evaluation, finalization of tenders for 4 numbers of firefighting works inside SCB Medical College and Hospital. To stop by the said communication, the Election Commission of India has granted no objection certificate for the finalization of said tenders subject to the condition that the MCC Model Code of Conduct provisions are not violated in any manner. First off, the said communication of the Election Commission of India has been transmitted by the Chief Electoral Officer Odisha to the Additional Secretary, GA and PG Department. And also to the Work Department. General Administration and
Pension grievances. Public grievance.
Public Grievance Department, Government of Odisha, wide letter number 9975
And Works Department.
dated 21/5/2024.
And Works Department.
And also to the additional secretary.
A copy of the said communication has also been transmitted to the Additional Secretary to the Government, Works Department for information and necessary action. First off, we record our deep appreciation for the expeditious step taken by the Election Commission of India in the matter of grant of no objection certificate, keeping in mind the urgent requirement of firefighting system inside the SCB Medical College and Hospital. List this matter on when? After vacation, 24th June?
Yes. Lordship may direct that necessary follow-up action to be taken by the state authorities.
The court expects that the respondents shall, that the state opposite parties shall proceed now with all promptitude and seriousness.
My lord, the appearance of may kindly be noted. DG is there.
DG Sudhanshu.
Dr.
Sudhanshu also has joined the court proceeding online. So now with the Election Commission, we are very appreciative of the manner in which the Election Commission of India has granted NOC. Now,
grateful,
the department should proceed.
Item number 31.
31 minutes, I talked to the director, secondary, he is plus saying that he is in the process of doing it. I only pray no lordship fixed on the 18th minute. If he does it all right, otherwise lordship may direct his personal because
yes, pass that conditional order.
By way of last indulgence, list this matter on 18th.
If not complied, we appear in person.
List this matter on by way of last indulgence, so as to give the contemners another opportunity to comply with the court's order, violation of which has been alleged in the present contempt applications. List this matter on 18th. First off, if on the next date the contemners fail to comply with the contemner, which contemner?
Secretary and the director.
Secretary and
director. Both are the party to the
party position. What is the system? Respondent one.
Respondent two.
Respondent or opposite party? What do you call respondent or
opposite parties? Contemners.
Contemner opposite party number 2 can be required to be present in court for this court to consider initiation of contempt proceeding against him with the framing of charge.
For orders, item 42.
Matter, job contract matter on limitation of pay your loss issue notice.
What is the delay?
Delay, there is a delay of 300 days. 320 days.
Why should we?
That's the job contract matter. Similar matter has been issued, notice has been issued,
right.
and the
All right.
Item 43.
That pension to job
yes,
contract.
yes.
Full pension or that?
Full pension. That Nityananda Biswap, that full period, we have granted him minimum pension.
That much of service which will qualify. That will added to the.
Yes, ma'am. We have granted him minimum pension, taking into account the shortage of service for the qualifying period. But this Honorable Single Judge had directed to grant him full pension. Sorry, ma'am. 43, 40 days delay.
43, 42. I'll call it 40.
43.
43, 40 days delay.
Item 43.
40 days delay, that is pensionary benefit, sort of product.
Item 44.
44, my lord, 79 days delays, that's South Florida case.
Limitation.
Item 45.
45, my lord. My lord, the order dated 2/5/23 is at Annex 2 at page, from page 14 to 18. My lord, may kindly straight away come to page 18, please. Page 18.
Yes.
My lord, may kindly see the last line of paragraph 5. The view taken in this court in the case of Dr. Ambuja Satpathy. Accordingly,
sorry, seems item number.
My lord, this is item 45. 832, my lord.
832.
Yes, my lord.
Yes.
My lord is looking at page 17.
Page 17.
My lord, 17.
Yes, 7.
Paragraph 5, last 2 lines, ma'am.
No, there's something else.
This WA 832 of 2023.
24, man.
23.
Oh, wrong.
He is holding the wrong brief.
23 is listed.
He is holding the wrong brief. That is 24.
23 Sarath Florida.
I'm sorry, my lord. I have got 832 24 file wrong.
832 is Sarath Florida.
Extremely sorry.
All right. Is this matter on? Huh? What is it?
Sarath Florida. 832, 45.
45. What is it?
45. Delay.
Florida notice.
110.
Issue notice.
Item 46.
Item 46, my lord, I don't have a.
There we have issued notice. Take it down.
Well,
so that we will comply with requisites and other.
Grateful. My lord, item 46, my lord, I don't have a case on merit. My lord, may kindly dismiss. On limitation, my lord, 410 days.
12 days delay.
410 days.
412 days.
12 days.
My lord, 412.
IA number 2. Which one? 2197? 2197.
859.
IA number 2197 of 2023. This appeal has been, this application has been filed seeking condonation of delay of 404 days in preferring the intra-court appeal. Full stop. The order of this court was passed on 9/2/2022, whereas this appeal came to be filed on when 26/4/2023. 26/4/2023.
27/4, I think.
26. 26/4/2023. Full stop. Hmm. 27/4/2020.
Rafiq machine. Rafiq machine.
Not traffic machine, my lord. My lord will remember, these work charge employees, they were brought over with effect from 1/3/2009. Now, these persons joined 3-4 months after. So, by
Amount
decision
was
of this
given,
court
but
is, they are to be
recovery.
paid from 1/3/2009. That 4-5 months, writ appeal has been preferred.
The respondent was a work charge employee.
My lord.
Full stop. Except for slow pace of movement of the file in the departments of the government, comma, though there is no other justifiable explanation available on record for condonation of delay. So this application is accordingly dismissed. Consequently, yes.
Item 47.
Item 47, my lords, inadvertently the requisites could not have been filed. My lords, I pray by tomorrow we'll file the requisites. Wide order dated 23/4, my lords had directed to file requisites.
2 weeks further time is allowed
I'm good.
for
Deep-
filing the requisites, complying with the order dated 23/4/2024.
Yes, my lords. 23/4/2020.
Yes.
I'm grateful, my lords.
Item 48.
Lord, item 48 maybe after vacation. In the meantime, I'll remove the defects. And so far as delay is concerned, the order dated 1st of November 2023 is under challenge, my lord, and filed within 30 days, my lord. On the last day of that, I will verify, my lord.
So first, you will have to remove the defect.
Yes, my lord.
Let the defects be removed. 8 weeks time is allowed for the appellant to remove the defects as pointed out by the stamp reporter. Yes.
Item 49. Madam, 49. The 250 days delay, madam. Notice to go on limitation. Notice to go on limitation.
Merit?
Merit, I have case, madam, because this honorable single judge has allowed the prayer. That judgment, your lordship know that Tarshan Singh case, that limitation period of 3 years granting that financial benefit, that has not been taken into account. On that score, I have a case.
So notice.
A batch of writ
Yes,
petitions
batch
were
of
called.
4950 same.
No. WPC 20713 of 2016.
My all those cases are under challenge. Next case is also same. A batch of that or
No, 20713 you challenged.
yes, ma'am. Next matter is also same matter.
Yes.
Item 49. Admin order. Limitation to show issue. And it was found that it turned after the service. It is only listed in publish.
No, but defects are there.
No.
Defects are over.
In 49 where defects are there, ma'am.
The 49. Notices have been issued.
42nd.
Yes,
Yes,
notices were issued.
yes, my lord, on 6 for 2000,
22
on
for
22 for
2024.
2024 notice has been issued, none has appeared, my lord.
Wrongly listed. For
Yes,
this matter is under appropriate heading.
Item 50. In this case, notice has been issued.
I've appeared for the respondents, your lordship. I'm
One-
on VC, your lordship.
159 days delay, ma'am.
So what do you say, madam? Should we
It's
condone?
long. Yes, your lordship may condone and decide.
Condone. Third, so. List for admission.
Item 51. 51, may I frame, my lord, this matter?
Copy of the writ appeal may be served on.
I'll serve.
Obliged.
By tomorrow, I'll serve.
Item 51.
In 51, may I frame, my lord, this matter come after vacation, my lord. There is also limitation. Why I am praying, well, your lordship has fixed the matter, the limitation on, so let it come after vacation, after judgment of this, my lords. 420 days delay.
It's on more than 500 days. There is a long delay of that.
I am submitting that.
My lord sort of similar matter dismissing. My lord similar matter dismiss the appeal.
Similar limitation matter has been not
more
like this.
More than 500 days.
Vacation টা enjoy করুন
My lord.
vacation টা enjoy করুন
Has my lords. My lord.
balance টা খুব পড়ে যাচ্ছে
As requested.
Where some merit is there, there I am on limitation, I am pressing for issuance of notice. Where no merit.
disastrous
Yes,
disastrous
yes.
Item 52.
In item 52, 900 days delay there. But in the ground of challenge that during pendence of departmental proceeding and criminal case, direction was issued to give him promotion. In the meantime, admittedly, he has been exonerated in the departmental proceeding as well as in the criminal, he has acquitted in the criminal case. He has relied on, in that IA, he has relied on order, my lord. That is also is covered by that.
I filed an affidavit, my lord, on 13/5/2024. Lordship can see page 42 and 44, my lord. There are two orders passed by this honorable court, where squarely covers this my lord, case of the respondent. There, my lord, the respondent was acquitted in the criminal case, and your lordship passed the order, my lord, directing that having
That
had
should not be precedent for other cases because others are relying that judgment. So there should not be precedent for other
No,
cases.
what had happened in his case?
In this case, my lord, yes, my lord, direction was given to give him promotion during pendence of that criminal case and departmental proceeding.
You challenge that.
During pendence of this, in the meantime, he has been acquitted in that criminal case and exonerated in the departmental proceeding.
So what are you challenging now?
No, so, my lord, this is the case. We cannot, because at that point of time, he was not exonerated.
All right. So even without entering into the question which has been decided by a single judge, he is entitled for all the reliefs.
Yes, ma'am. Now he is entitled to all the reliefs.
So give him.
Yes, ma'am. That now he is entitled because in view of the changing circumstances, he is entitled to all the reliefs.
In that case, we will not go into the.
Yes, that I am saying.
We are listing it for on 19th of June, within first 5 cases. In the meanwhile, whether decision has been taken
After acquittal.
after acquittal.
No, ma'am.
When was the acquittal recorded?
I has filed that in that affidavit on 24/3/2023.
Well, on 24 March 2023, he was acquitted.
And on 7/12/2023, in departmental proceeding, he has been exonerated.
The respondent had approached this court seeking direction to the officials of the state of Orissa to grant him promotion to the post of what is OTAS?
Odisha Taxation Service, madam.
Odisha Taxation and Account Service.
And account service.
Post of
OTAS.
Orissa Taxation and Account Service with effect from 7/2/2014 and OFS hyphen capital 1 bracketed JB from 5/1/2021, comma, that is the dates with effect from which his immediate juniors were granted such promotion. Full stop. And single judge of this court disposed of the said writ application with an observation that the pendency of vigilance case cannot come in way, could not come in way of the consideration of the petitioner's case for grant of promotion. Full stop. Disciplinary proceeding was also initiated against him. Full stop. Learned single judge disposed of the writ application with the following observation. Fact involving जहां से शुरू होता है page 13. Stop. The said order of learned single judge dated 16/9/2021 is under challenge in the present intra-court appeal. Stop. It has emerged, comma, based on the submissions advanced at the bar, that the petitioner, that the respondent has been exonerated of the charge in the departmental proceeding and has been acquitted in the criminal case. So stop. Next. In view of the changed circumstance, we do not intend to enter into the question enter into the correctness or otherwise of the order dated 16/9 to impugn order dated 16/9/2021 passed by the London single judge. Stop. Without disposing of the writ petition, we deem it proper to adjourn the matter to first week of July. So stop. In the meanwhile, the state respondents shall be under obligation to take a decision on the petitioner's claim of the respondent for grant of promotion in accordance with law, consequent upon his acquittal in the criminal case and exoneration of the charge in the departmental proceeding.
Your Lordship, we can dispose up with that.
No,
Yes.
we will not dispose.
Well.
We will wait.
Well.
Otherwise, he may have to file a contempt petition.
Contempt has been filed.
Contempt petition has been filed. No, he will.
So that's why I'm saying if it will be disposed of,
Do it.
so that we can comply.
Otherwise, we will take up that contempt.
Yes. That's why I was submitting, because we'll get that opportunity till July.
Do it.
Well,
Item 53.
Oh.
53.
53 appeal memo may be along with the limitation may be served upon me, and I file my objection. And put up
So what is the delay?
131 days. 131 days.
You can concede.
delay টা consider কলে delay টা control নেলে আসিব ম্যাটারটা after vacation.
So that will expedite. See, if you have merit.
Yes.
All right.
Yes.
Then that will expedite disposal of writ appeal.
Absolutely.
If there is no merit, then you may.
131 days delay control করিয়ার objection ଅଛି.
I will run counsel on behalf of the appellant and the concerned respondent. IE number 7. There is a delay of 130 days.
31 days.
131 days
131.
in filing the present intra-court appeal on behalf of the state of Odisha. So, no serious objection has been raised to the prayer for condonation of delay. Stop considering the facts and circumstances. The delay in filing the appeal is condoned. Unless this appeal for fresh admission.
Fix a date,
I'm heading fresh admission.
Pray for a
It
fix
will
a
come.
date.
All fresh admissions are coming. Marking listed.
Date may be.
Item, date ହେଇ ଯାଇଛି.
We will see, Mr.
Item 54.
54, my lord, rehabilitation assistance appointment, Bindu Sagar case, notice, my lord.
Notice on limitation.
Limitation, my lord, 159.
Notice on limitation.
Item 55.
Miller, I filed a modification for order, Miller.
Modification.
modification of the order. Well, that, that is dated. The only the point is, my lord,
A review in the garb of
my
modification.
lord, only review means I am not reviewing the entire order, my lord. Only the to the extent that imposition of fine, my lord.
Why should you appear? Ask him to appear, the petitioner in person. Let us see
That
let us see what we have said.
only difficulties, my lord. He is not proper to address this honorable court. That is why all these things happen, my lord. He could not convey the facts in details. He appeared in person. That is the problem, my lord.
No, we remember Mr. Siddharth
Well,
Das was appearing.
That is what
And
I pray my lord's indulgence.
He withdrew his wakalat. Thereafter, the person concerned argued. And he insisted for pressing this application, and we heard him.
He is not conversant with the procedure of the court, my lord.
He is a
That is
company
why,
secretary, sir.
Mr. Counsel,
He is company secretary. You say he is not well versed with legal aspects.
that is not there. That is why only
we may enhance the amount because you are again justifying.
justifying, my lord. Only case is, my lord held impression is I am a politician. I am not a.
No, you are not a politician. We are not saying that you are a politician. We had just observed that a matter of 2019 was being rigged up.
That is
The circumstance in which that was rigged up, we had noticed. Now, if you want to file a review, you can file a review. We may enhance, we may reduce, we may allow your review application.
Okay, blood, it is not pressed with liberty.
IA number so and so. This application is dismissed as not pressed with a liberty to the petitioner, to the applicant to prefer a review application, if so advised.
For admission, item 56.
But 56, I'm in virtual mode. Yesterday only, Mr. Panigre has served 3 copies of the counter affidavits. I need instruction. Specific if this matter after vacation. 56, my lord. I'm virtual. Pardon me, Lord, I'm virtual mode. Yesterday, Mr. Panigrahi has served 3 copies of the counters on all 3 matters. I did matter may be taken up application so that I can respond to it.
What is this matter about? 12-year-old matter?
The matter is about sale deed has been challenged. Sale deed of the year 1966 was under challenge before the learned Commissioner of Endowment, and without touching the vital question of law regarding the Odisha estate abolition, the right which has been extinguished by the petitioner, that has been ordered. Now, Mr. Panigrahi, by this counter, has also raised certain new points which is required to be responded to. One new document has been filed. So therefore, I pray, may I pray, my lord, can be reopening day.
No, we'll see if he is filing new documents,
I
then
have-
cannot be permitted. Yes.
Yes, I have filed
sought
my
the copy of the counter, Millard. I am filing it in course of the day before the registry, Millard.
No counter. This writ petition was filed in 2012.
But
Why should we allow him to file counter affidavit in 2024?
No, Millard, in December 2023, I appeared and your lordship allowed me to file the counter affidavit.
So before 2023?
No, Millard, I appeared in December 2023.
Why did you appear in 2023?
Well, pursuant to press notice issued by the Sound Court, I appeared in 2023. Millard.
All right. Have you given copy?
Yes, Millard, I have given copy.
And counsel for the
I have received affidavit.
seeks adjournment to file rejoinder to the counter affidavit which has been filed on behalf of
Opposite party number 1.
opposite party number 1. Most optimal is this around July.
Item number 57.
Interim orders are there, my lord. My lord, may permit.
Item 57.
Interim orders.
57. May I please, Lordship? Lordship, there is a noting. The notice was issued to OP number 20 and
Note 7.
there is beautiful.
7 after some time. It is not legal errors of OP number 7.
Lordship, noting has come. The OP number 20 has died. Notice was issued to them, but so I have to take steps for substitution.
Let us see what is this matter about.
Lordship. The petitioner is challenging the order
died?
of the pardon?
Who died?
The opposite party number 20.
What is this matter about?
Yes.
So everyone will die because this is of 2015.
Yes,
We are in
but the notice has been
2024.
sent. But the notice
7
has,
died, 20 died.
but the notice was issued
And
in
by
the year
the time
2023.
the notices are served upon or the substitutions are allowed, others will also die. And finally,
Because the notice was issued by this honorable court in the year 2023. So thereafter, it has come to our knowledge that the OP number 20 has died.
all right, what is this matter about? Therefore, we want to know. Why should
The
such
matter is
matters?
the petitioners are challenging the order of the member board of revenue passed in OEA revision case number 94 of 1981.
Yes.
Confirming the order of order
Yes.
passed in appeal
Again.
by the additional district
Yes,
magistrate.
both the courts order.
So factually, it is over.
No,
On facts, it is over.
no, yes. On fact, it is over. The counter and rejoinder are also in file.
And why was this writ petition filed in 2015
Lordship,
against an order passed in 1984?
Another writ petition was filed, but it was dismissed for default. Thereafter, the restoration has been filed by the father of the petitioners. It was also dismissed on the ground of limitation. It is the subsequent writ application.
No. We should not allow such.
Lordship, the issues involved in this case is the original order passed by the Tahsildar is without jurisdiction, as the power has not been vested to him. It is the ground of challenge.
Mr. Counsel, we are struggling with an order which was passed in 1984 in a proceeding which was filed in 2015.
It is the subsequent application, Lordship.
Subsequent application, how can we, why should we maintain?
Because it was dismissed for default. It was not in merits.
When was that dismissed for default? And did you apply for restoration?
Yes, the restoration was also dismissed.
Then
It is 24957 of 2015.
Then you could have sought a liberty to file a fresh application.
No, Lordship, only ground of challenge is the
Then
order.
No proceeding can come to an end.
Lordship,
And
keep
the
the
best
matter
way-
to after vacation. I will.
No vacation.
Lordship, because the ground of challenge is the order passed by the Tahsildar is without jurisdiction.
Maybe.
On that score, the writ petition is maintainable, Your Lordship.
Writ petition may be maintainable, but not in 2015.
Lordship, grant one opportunity at least. After vacation, Your Lordship.
We can fix old matters.
Lordship, may fix a
One day
date.
for one day for old matters. Very old matters are unnecessarily pending because of this.
Lordship, on the reopening day, Your Lordship. May fix.
What reopening day? You get your writ petition dismissed. And thereafter you file restoration petition. You don't seek a liberty. And then you are again filing. How the second writ application can be maintained? Should be maintained? Why?
Lordship, the res judicata will not bar when the order passed by
Res judicata may not be barred, but your conduct will disentitle you for any relief.
The Lordship may put the matter to after vacation.
Yes, Mr. Please address us on this point.
That ground I have taken in my counter affidavit, your Lordship may see that this ground only is liable to it appears from the impugned order passed by the member board of revenue Odisha that the same having been passed way back in the year 1984 as of filing of writ petition, there had been a substantial period of delay of about 31 years, and there being no possible reason for such inordinate delay, writ petition, this ground is liable to be dismissed. That ground we have taken in the counter.
Unnecessarily.
Lordship may grant one opportunity at least.
This
Mr.
jurisdiction.
Mishra is appearing in this case.
This jurisdiction, where have you stated? In your grounds?
Lordship,
Where have you taken the ground that the Tahsildar did
Tahsildar
not
had
have the jurisdiction?
You are saying they were wrong in deciding the issue, not that the authority
Under
was
the OA Act,
lacking
Tahsildar is
jurisdiction.
the competent
Lack of
authority.
jurisdiction was never
yes, Lordship,
questioned.
because
Arbitrary exercise of power and lacking jurisdiction is two different things.
Lordship may kindly come to paragraph 11, page 11, paragraph 11 of writ petition.
11. Para 10 letter atla
OEA court has no power.
Paragraph 11 and 12. 12 bottom. I have stated specifically the order passed by the Tahsildar as well as the sub-collector is without jurisdiction.
Why? They are not vested with power.
No, Your Lordship. The power has not been vested to Tahsildar. And he has initiated the 5A proceeding.
Under the OE Act, Tahsildar is the competent authority. You
Let them show at least. I have.
No,
So let them show, he is there to show.
Lordship, they have
You
not
show.
because I have annexed. Your Lordship may kindly have a glance to the rejoinder affidavit.
Then who is vested with that power?
Sub-collector.
From where you get it?
No, because appellate authority has is the ADM.
So you are basing your submissions on what?
Lordship may kindly come to my rejoinder affidavit.
Rejoinder affidavit is the law.
No, I have annexed the notification, Your Lordship.
All right.
Page 40. Sorry. Page 81.
Page 81.
80. Starts from page 80.
Annexure?
Annexure 18.
This is of the year
Yeah,
1963. SDO is empowered.
Yes.
Yeah, annexure 18. Additional affidavit.
Under 5.1 of the OEA.
Yes. Power vested with the sub-collector, but the Tahsildar has initiated the proceeding.
The order is passed by the no. Order is
The
passed,
order has been passed.
1976.
Yes, Lordship, what has
That
happened?
is,
The Tahsildar has initiated the 5A proceeding.
From where
He has inquired into the
from where
matter.
you get it?
Lordship may kindly come to the writ petition. Sorry, pardon.
On the report of Tahsildar, the case is
No, Your Lordship.
indicated.
Lordship,
You see-
I'll show you, Lordship.
You see order at page annexure 1 to your writ petition.
Yes.
First sentence.
Lordship.
This is a case under section 5.1 of the OEA Act.
Yes.
Instituted as on the report of
Yes.
Tahsildar.
Yes, but Your Lordship may
that
kindly.
means it is initiated by SDO.
Lordship may kindly come to annexure 8 for a moment. The order passed by the Tahsildar.
Annexure
Page 28 of the
See,
rejoinder.
we are of the prima facie view that you are getting your writ petition dismissed intentionally. Because you knew that you do not have any case. Therefore, just to keep the list alive, you have allowed this to continue.
I pray for only a short adjournment for
What
after vacation.
adjournment?
After vacation, reopening day, Your Lordship may fix.
All right, as requested on behalf of the petitioner, list this matter on 18/6/2024 to be taken up at 2 p.m. First off, we make it clear that on the said date, the court shall not grant any adjournment, keeping in mind the fact that the writ application has remained pending for 9 years.
This annexure 8, again, Tahsildar states in his order sheet that I am satisfied that there is a prima facie case under section 5.1 of the OEA Act and the case record is submitted to SDO for favor of necessary
That
action.
is not
So
permit-
SDO has
that-
taken action and
That
yes,
is not permitted
So,
because
it
he
is
has
not lack of
initiated the
jurisdiction.
5A proceeding.
You are challenging the lack of jurisdiction of Tahsildar. Tahsildar has given only report. He has seen the record and he has sent it for appropriate action by the SDO. SDO has initiated action and he has concluded the proceeding under section 5(1).
I
And you are
examine.
mistaken.
I will examine.
Who is Tahsildar? No,
hierarchy. The
Tahsildar is the lowest
Tahsildar is the lowest
authority, then sub-collector, then ADM, then collector.
circle officer type, circle all that.
Sub-collector.
Or circle inspector, something.
Sub-collector.
No, Tahsildar is what? Circle
No,
Tahsildar?
OS.
Is it-
Orissa administrative service.
Orissa.
He is
So
also
it
an
must be-
administrative officer.
All right.
Group B.
Group
He is now Group B. Earlier it was Group.
So SDO is above
class two.
Tahsildar.
The sub-collector is above Tahsildar.
Sub collector is above Tahsildar. And there
Under
are
one sub-collector, there are 5 to 6 Tahsildars.
all right.
From 58.
May please your lordship, this is a public interest litigation, my lord. Matter relates to protection, preservation and conservation of water bodies and jalasayas in Cuttack city, my lord. This matter was previously was listed on 5th February 2024 in WPC number 22990 of 2014, my lord. On the said date, this honorable court has passed an order which is at para 5 and 6 in writ application number 22990 of 2014.
Before my
I would like
senior
to place.
starts, may I submit one thing? This is also relating to the Cuttack city problems, some jalas. If your lordship so desires, I am not pressing for that. It can be tagged with that Cuttack PIL because that PIL, it is also for Cuttack city.
That was the submission which was being made earlier.
Yeah, so
And which we had declined.
okay, then I'm sorry. I'm extremely sorry.
We can reconsider.
Yes.
That matter also can be taken up
All right.
by this honorable
But
bench.
lordship, only I pray lordship, that may be allowed, but in the interim major lordship, I may protect it. Now they're trying to lordship fill up the entire water bodies lordship. That's why my miscase is there lordship. I filed the intervention.
That intervention,
Yes,
that is not allowed.
No, yes.
You have filed a separate writ application or?
No, lordship. In this case, because this there is some matter is pending before lordship by a public and litigation. I preferred this interim application for lordship intervention, and I have also prepared another interim application for maintaining status quo lordship. Now that the hooligans are going to fill up the entire jalasaya.
Hooligans can do anything.
Lordship, that's why lordship.
If the state is doing something, it's a different matter.
Lordship.
But if some private individual is doing, they can do.
But
The
lordship,
states are.
lordship is category given a direction to the municipal corporation to look after the matter. Lordship can have judgments or two judgments.
All right, judgments you can show later.
But lordship, I
All
may
right,
be.
not now.
But lordship,
Not-
kindly say one submission, lordship. Lordship, can I remember that last 11th lordship Saturday, 1 hour rain lordship disturbed the entire Cuttack city. And lordship, particular this year, if lordship, they will fill up the jalasaya. And by this time, another rain will come.
Mr. There can, if any emergent situation arises, you can make a mention even during the vacation. Urgent matters can be taken up. It's not that.
That's true, lordship. But lordship, kindly say on 22nd, another rain is coming, lordship, due to low pressure. Since lordship from tomorrow, lordship.
Therefore, there should be no encroachment.
No. Lordship, that's why lordship. Only I am praying lordship because I have filed a mistake.
Hey, interim order.
No, lordship. What happened? I'm not praying for interim lordship because I have filed an interim application. At the same time, I have also served copy on the opposite party, Lord State government and municipal corporation. Lord, they should be vigilant on the issue, lordship, so that
They will be vigilant.
lordship,
Once
that
you have
only
brought
that objection that because I may. But
Your apprehension is if it is filled up, then the water clog will be more.
Lordship, all the eminent lawyer lordship, they are saying.
Sir, please understand the difference.
Lordship.
If the state is doing something which is against public interest, we can restrain them from doing that. But if according to you, there are some hooligans,
No.
they are doing that. So for them, either the state shall take action, or
Gotcha.
otherwise, as I
We can
always
clause
give this
effect.
example, that we cannot issue a direction that there
Right.
shall not be any theft
Lordship.
in future. So
But-
this order we cannot give.
No, only Lordship, now Lordship, before Lordship, inaction of the state is under challenge because,
Inaction.
because there the Lordship's order is there. We have approached them, Lordship can see our miscase. Lordship, we have approached them, Lordship, anticipating Lordship
Then-
and after, so they should Lordship take.
See, we see no reason why the state respondents shall not take action, shall not be vigilant. They shall be vigilant. They are also interested in your interest. The court just plays a role of catalyst, or sometimes and sometimes they also need some orders from the court.
Now, what I,
All right.
one line observation will suffice for me, Lordship, because it is public and
No,
litigation.
Have you served?
Yes, Lordship, I have sought copy on then, Lordship. So only one line observation, they will be vigilant,
Have
Lordship.
an instruction
My lord,
right now.
my lord, this
Last evening, I got a soft copy. Right now, I'm about to.
No, I have sought copy on the state the very day.
If you,
And
if you
CNC
can
Lordship,
see earlier orders of this court is carried out in its letter and spirit, you can also take instruction.
Cuttack PL bench, the matter will be, this matter will be assigned to the Cuttack PL bench. Obliged.
That is better. Earlier directions were there.
Yes,
But this,
my lord,
With regard to
only-
if
Jalasai
any
and Cuttack-
hooligan is doing anything,
If any order is passed and that is violated, then there is contempt jurisdiction also. So that
Yes.
can be taken care of.
Yes.
Right. So if there is any order that has been violated, you can bring that to the notice of the court. You'll see. So that bench is different.
Lordship, but vacation is that side, Lordship. Lordship, can I move Lordship on 23rd, Lordship, that same bench is Honorable Justice?
That we cannot say. You may make a mention, depends on that bench to
We
consider.
are appending 22nd, Lordship, that monsoon is.
Make a mention.
so urgent. କଣ ଦି ଦିନ ଭିତରେ ପୋତି ପକେଇବେ?
Lordship, can I say photographs, Lordship? They're really good, Lordship.
Mr. Ajay Mahanti is
entire-
very vigilant. Mr. Ajay Mahanti is sufficient. He is very vigilant.
They are doing it.
That apart, if somebody will do some illegal act,
Whether
you can lodge
Mr.
FIR
Mohanty is resident of Cuttack or not.
But Lordship, he is staying in a safe area, Lordship.
No, no.
But in this
His
particular.
area is most
vulnerable.
Sutahat area.
Lordship, here, Lordship, just assume this plot, Honorable Chief Justice of India also residing, Lordship. Justice J.B. Patnaik, Justice B.P. Das, all eminent lawyers, Lordship, residing just adjacent to this
Therefore,
utter body, Lordship.
everyone. Yes.
Item.
I'm the petitioner in the first with matter. That is writ appeal 949 of 2021. Milord, what I pray, this is to be argued my
WA 146.
No, I am in WA 949 of 2021. That is first with matter. I am the petitioner there. All Odisha government ITI instructors. I pray, Milord, I pray on behalf of senior advocate Mr. Saurya Sundar Das that he is not well. Let it be taken up after vacation.
What is this matter about?
This is the matter relating to regularization of some employees, those who are appointed part-time. But their care was either they will be treated contractual or regular. And the matter was before the honorable tribunal. Tribunal once disposed of the matter, directing that they file a counter that we are taking step on the basis of that. Tribunal disposed of that you must do it in a particular way. Right. Then the matter is carried to this honorable court. Some matter have been disposed of by the honorable single judge, where direction has been made that to create the post because they have been working for a long time. So at least to take steps for regularization of that. But the honorable single judge will impugn order dismissed it by various judgments. So you also have issued notice and the recruitment, if any, shall be subject to the discharge of the present appeal. That was the order which was passed on 10/1/2022. So my learned friends want that because he's senior is doing that first meeting. So keep it to only that
As requested on behalf of the appellants, this matter on July.
I don't know. Item 60.
Item 60 that last I remember about the traffic police of the transport matter. Last occasion matter to keep it after vacation.
Already this matter, already several occasions they have adjourned the matter.
2 years, my lord, already passed. 2 years
Yes,
already
that-
passed. My lord. Every day, your lordship see the order. Time.
Apart from the judgment of the Bombay.
No, Bombay High Court.
Let them argue. Let us
Yes,
see.
What I'm praying, my lord, what
We have understood that you prayed, they are objecting.
Your lordship.
Yes, this is PIL.
No, well,
No, not PL.
individual additional
person.
fee of rupees 50 fine, my lord. In the act itself, my lord.
This is WPC 23387.
My lord, and friend, thereafter, my lord, all
My
the
lord.
cases, my.
I prepare my lords with one preliminary notes of argument, only 4
Did-
pages.
did,
Your lordship may go through it. Here, my lords. The first, my lords. This notification, my lord, is issued in 2021 by the annexure 6, my lords. Your lordship, I would praise before your lordship the notification annexure 6, my lords. That is page 56, my lords. Annexure 5, my lords, page 56, my lords. Here, this notification.
Just a minute. What is the Supreme Court order?
That is pending, my lords. That earlier decision, that is pending, my lords. That has been in 2016, that has been, this honorable court has struck down both the notification 2016. That has been pending before the Supreme Court, my lords. No stay has been granted.
Previous notification.
But we are 2021, that is a different notification. We are challenging that one, my lords.
Self and putting, my lord. Your lordship rupees 55 in that 2016.
Under different provision
Yes.
of the Act.
Yes.
They have exercised.
Yes, yes.
Earlier, they exercised one provision
Yes.
where this court held that the additional fees cannot be levied in exercise of that power. So that has gone to Supreme Court. Along with other
Other
states,
high courts, my lord.
That's Madras High Court is already
are
challenged.
also pending before the.
No stay has
Supreme
been
Court.
granted. Well,
So during the pendency of that case, the state has now invoked another provision of law
Yes.
saying that they have the power in that provision of
My
law
lord.
that you are under.
Yes.
That notification is under.
not state, my lord, same union government. Same union government. Well, that is the notification of union government. And this
Maybe,
also
But
2000.
that has been,
different power.
that has been stayed by Karnataka High Court.
Karnataka High Court, my.
So if that has been stayed by Karnataka High Court, then why are you in hurry?
My lord, why
But you are paying here by-
We are the truck owners, my lord. We are, let
my
your
lord.
lordship grant the stay, my lord, so that.
No, why is double stay?
No, because stay is granted by the Karnataka. They have not.
That is
Here, my lord,
applicable to
Odisha, they
that
have
state
imposed
only,
this.
my lord.
They have collecting the 50 rupees fine. Odisha.
Why Odisha, who is collecting?
That is
State
state
transport
collecting,
authority.
my lord.
Transport
Transport
Commissioner.
authority, they may be collecting, but once the notification has been stayed by a high court,
My lord.
then notification, the stay shall operate throughout the country.
That is your lordship is right.
The notification itself has been stayed, then it has been stayed.
Central rules.
Kerala High Court is also state, my lord.
Yes, central rules.
Your lordship is right, man.
But the Bombay High Court has taken a different.
Clarify that, my lord. Your lordship.
Honorable Bombay High Court has taken a different.
That is old,
No,
old,
no, 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 no.
old notification.
Old notification, my lord. Bombay.
Very difficult. It's very difficult. If the particular notification has been issued, who had been stayed by a high court, then it is very difficult.
That's why my lord has observed that no, we will give an independent decision in this regard and
Independent for the purpose of final adjudication.
Yes. My lord has said so. Yes.
For the purpose of final
As
adjudication.
regard to the collection of the levy, yes.
Your lordship.
But once the notification has been stayed, then
Two High Courts, my lord. Kerala High Court.
suppose if the
also Karnataka
notification
High
is
Court.
caused, just if the notification is caused, then notification will have to be caused by all the high courts.
Exactly. Exactly. Yes.
Exactly.
Pardon me.
Protect us, my lord. said.
Unless the decision of the correctness of the decision is routed by another high court, then of course, otherwise, till that is caused, that is caused.
But in the NCR in Delhi, they are collecting.
Then so many things are happening.
Yes.
It may not be brought into the notice.
So
of
what
the-
I am praying, my lord, biddings are not been completed. Let's may keep it to first week of July. Then we will complete the.
And who is collecting?
For the state,
my lord.
Just
state council,
why are you?
I will inform them.
Transport
It is not a state,
Commissioner.
the council for the transport will appear.
Your lordship transport comes.
Yes.
Mr. Prabhakar Behra.
If it's a general order stay by the government, then it is applicable throughout the country.
Throughout the Odisha.
What is the nature?
So
What is the nature of the order?
What is that?
What is the nature of the order passed by Karnataka High
Yeah.
Court?
We have already submitted.
Already
Your
submitted
lordship,
last
that is
time. Your
fine,
lordship's
madam.
order.
We have already there.
Your lordship.
Yes, but
Kerala High
still we
Court
would
and-
like to see.
See,
We
the-
don't remember everything.
Your lordship. Okay.
The first case ଅଛି.
Karnataka High
Mr.
Court.
Samantara, you are not party here.
Karnataka High Court and
Only transport authority is the party of.
Here is the case after 2016 policy, the scrapping policy came into force. And after scrapping, introduced the scrapping policy, 2000.
it is already we have filed on that day.
Filed in the
First case that
First
is
case, your
filed.
lordship copy is there. And your lordship, last order, your lordship dictated that notification, my lord.
Yes,
Karnataka High Court order. Last.
No, but still we have not, we don't remember the nature of the order which was.
The annexure.
Yes,
that
you
notification.
provide the
has
copy
already
to the
been-
honorable court and myself, we are not given.
No, that I have already supplied.
No,
copy.
that annexure has already been stayed. That annexure 2 meant that means 2021 notification, my
That
lord.
is separately. That is a loose copy. That is not attached with the writ.
But your lordship order also reflected that. Annexure 2, my lord, that has been stayed. That 2021 notification.
No, we want
With
just.
all respect, I am saying it is not the order against the notification of 2021.
Yes, yes,
Yes,
earlier,
yes,
yes, yes.
21.
Why you are, 2021 notification.
Where is that order?
My lord, it
You
filed.
also must be having
My
that
lord,
order.
I am one copy, my lord, I have no.
Then come on the first week, second week of 27th or something. 27 June.
Oblige, man.
Yes. Come on, 27 June. Let us.
Yeah.
I have a copy, I will supply my lords within 10
Please,
minutes.
please.
I have a copy, my
Your
lord.
lordship.
I will supply within 10 minutes.
Sorry, my lord. Oh, in the minute, I also read you. I
I have a copy, my lord.
Please give.
I will supply
Your
within 10
lordship,
minutes. my lord. I have a copy, my lord.
filed था, देखिए तुम देख लो.
Please give a copy to the council for the estate also.
Filed था दोनों.
Come in June.
देखिए दो.
That will be fine.
Oblige, man.
Item 61.
Item 61, may I please, Your Lordship? Your Lordship, in this writ appeal, Your Lordship, the order dated 23/12/2022 passed by the learned single bench has been challenged, wherein the prayer of the petitioner for to allow the closure of the term deposit accounts was rejected. Your Lordship, the fact of the case is that the husband of the appellant was proceeded under Rule 14 of CCA rules for.
Where is the order?
Well, last occasion, my lord directed to serve a affidavit and serve the copy. I'm sorry, my lord, the concerned counsel is ill, that's why I could not lodge me.
No, Your
After
Lordship,
vacation,
the
if I made
affidavit has been served. Your Lordship.
Sir, no?
No,
Then fine, sorry.
The
We
affid-
serve the copy of the affidavit and also file in the court. Then. The concerned counsel with me was not available, that's why.
It was served on the last occasion, Your Lordship.
So
Can we
keep
adjourn
it to another day, we'll assist the court for hearing because I don't.
Your Lordship,
He wants adjournment because land counsel is not here. This is what you say.
Yes, yes.
Your Lordship,
Counsel is appearing with me. She is not well, that's why.
Your Lordship, it involves a very short point if Your Lordship pleases.
No, but still, no one is to answer. And the land counsel who is for the Union of India is not present.
As Your Lordship pleases.
As requested on behalf of the Union of India. This matter. Second week.
Your Lordship, a short date may be fixed.
Second week of June. There cannot be any shorter date.
Obliged, Your Lordship.
62.
My lord, item 62, I pray for an adjournment, my lord.
It has been.
One of the matters, I think my senior Mr. Das is not well.
So-
Reference was made, so we can call it after the
After
holiday.
vacation, my lord.
After holiday, July.
Item 63.
Consider read matter, interim order to continue, my lord.
Order contempt matter.
My lord, there is a connected matter, read is also there. In read, status quo order is passed, my lord.
The interim order shall continue in the meanwhile.
In the read petition, in the read petition,
My lord,
the interim order is in the read petition.
my lord,
So in the writ petition is pending.
my lord.
The interim order passed in the location of person. Shall continue in the meanwhile. Yes.
Obliged.
Item number 63.
My lord, item 63, 1 week time to file complaints affidavit.
63.
63, man.
So compliance affidavit you will file only after the order has been complied with.
Yes, my lord, order taken a decision.
Huh?
The order was complied. Subsequently, we have filed compliance affidavit. But case is that.
That was rejected by this honorable
Yes,
court, my lord. My lord, may kindly see the order dated
Subsequently-
25 January.
Not side by side. Yes. 25th of January.
Yes, my lord. 25th January, my lord, the last order. Paragraph 3. Mr. Chandrakant Pradhan, Lord Senior Panel Counsel, appearing for the opposite party, states that he wants to file further affidavit in compliance with the order of this court. Therefore, this court is not inclined to call opposite party number 2, Mr. Ratan Jana, Senior Superintendent of Post Office, Puri Division, because he is relaying the matter, who has filed the compliance affidavit dated 22/12/23, and as such, the compliance affidavit so filed is hereby rejected. Their compliance affidavit was rejected. Then, my lord, giving an opportunity, the opposite parties are granted 1 week's time to file proper compliance affidavit. For that reason, my learned friend has noted it was passed in January. Now we are in May. Within 4 months, they could not file compliance affidavit after rejection of the compliance affidavit by this honorable court. And my case is covered to the case of Malayananda Sethi versus Union of India.
What was the order?
My lord, order, your lordship may kindly come to my contempt application, contempt petition, page 9. I have annexed the order passed by this honorable court.
What is the date of order?
Date of order is 18/11/22. Page 9. I have annexed, my lord. Paragraph 3 I am reading. The petitioner has filed this writ petition seeking to quash the order dated 7/10/20 under Annex 5, passed in ON number so and so, by which the Central and State Tribunal Cuttack Bench Cuttack has confirmed the order dated 21/6/2019, passed by the opposite party number 3, rejecting the application of the petitioner for compassionate appointment, and further to issue direction to the opposite parties to give compassionate appointment to the petitioner under rehabilitation assistance schemes as per prevailing guidelines circular of the department during the year 2001. 2001, this court has mentioned within a stipulated period. Mr. So-and-so learned counsel for the petitioner contended that the case of the petitioner is covered by the judgment of the apex court in the case of Malayananda Sethi versus State of Odisha in civil appeal number so-and-so, disposed of on 20th.
So what is the order? What is the compliance?
Manner they have not filed complaints properly. For that reason, this honorable court again rejected. No, you give him appointment, because in Malayananda Sethi case, honorable apex court said the date of death is the crucial date. And this court also observed that 2001 within a stipulated period. So I am approaching after the death of my father, my lord. They are delaying the matter. On the last occasion, they gave an undertaking before this court. Yes, we are complying the order passed by this honorable court.
Operative part of the order. Para 5. Here,
Whether you will comply with the order or not.
yes, my lord, so far as the Malayananda Sethi case is
They have misinterpreted.
Please allow him to.
My lord, sorry.
So far as Malayananda Sethi judgment is concerned, in view of that concern, we have taken a decision on at the time of giving the application. He has made application 2015.
No, 2001. Sorry.
And
I will not hear you. Please don't repeat it.
My lord, sorry.
In my court.
My lord,
Never.
My lord, extremely sorry.
July.
Item 64. Item 64.
I am direction. Lord, the DO Balapur has already calculated the period of your amount that comes to your rupees 33,87,000. On 7/5, he has made a requisition to the your department for payment. I've got the letter. After the holiday, so that in the meantime we can pay the amount. I also given a copy to my friend of this.
Lots, I have received.
So we should keep it pending or dispose it?
Lots, may keep it pending.
It is submitted by, in view of the submission made by Mr. Samantaral and AGA, that the authorities are in the process of complying with this court's order, violation of which has been alleged in the present contempt application. And the said order shall be fully complied with within a reasonable period of time. List this matter on July.
Item 65.
Item 65 is a contempt. Is a contempt against the railway. What happened after 40 years? Just file away and get the order. Order has been complied with and speaking order has been passed by the GM. But I suggested my friend, he is given two documents to us. One document is occupancy of quarter. Second document is providing about the reduction of provident fund. So that provident fund, I ascertained yesterday the officers are coming. It means here railway have a different provident fund account. So I requested him, let them get the document from their side on the RTI. I also verify this. If whatever possibility there, I am ready to assist. This officers, I requested them. It's a matter of pension, you take care of personally. And we are helping because after 40 years, because all the records are not available with the, because earlier it was South Eastern Railway, again it is East Coast Railway. So after bifurcation of the division, general office, they are scrutinizing same. So let's me keep after vacation. In the meanwhile, they are assured me if they any document they have found, they will submit to the court. Then it is easier for the. Otherwise, they have a fresh cause of action. They have to go file away and get the order from the court. Contempt has no role to play.
My lord, little bit with due respect, my lord.
Let us see the order. Where is the order?
Yes, my lord. The annexure 1, page 9 of the content petition. My lord, counsel for the petitioner states that the petitioner has received information on 20th February 2020 from the office of the senior
Let us
divisional.
see the operative plan.
My lord, he accordingly states that the petitioner will follow up the matter for grant of family pension with the East Coast Railway, reserving the petitioner's liberty to seek appropriate remedy. If there is a delay in her getting the family pension, the writ petition is disposed of. So, my lord, thereafter, page 28, my lord. Well, on previous occasion, I was drawing a lordship's attention. Page 28.
No, which order has been violated?
Yes, my lord. So there, for clarification, I filed an IA, and in the IA, page 28, this, my honorable court, page 28, my lord, the prayer in this IA is that there should be a specific time limit indicated for compliance with the direction issued by this court on 7th April 2021. In that view of the matter, a direction is issued to the General Manager, East Coast Railway, OP number 2.
Where is the order? You are alleging violation of an order. Where is that order which has been violated?
Yes, my lord. The order dated 1/11/2021. The complete steps be taken by the GM.
Where is that order?
Page 28.
Page 28.
Of this content petition, my lord.
All right. Let us come back to the order dated 7/4/2021.
My lord. Page annexure 1, page 9. This is regarding reconstruction of the service record of my deceased husband. So I.
Just a minute.
My lord.
Not my bad. Where is the order? There is no order. Please read it. There is no direction. No direction at all.
My lord,
Please read it 100 times.
No, lordship is right. But as per this honorable court order, the general manager held a personal hearing. I submitted the.
No, we will not go into that. Show us one direction which has been violated.
My lord, the direction part, page 28, the general manager is to take the final decision regarding steps taken.
Where is that direction?
Page 28.
So, where is the direction that the record, your survey book was required to be reconstructed? Where is the direction?
My lord, the My lord, on 20th February 2020, the page 9, the senior depot, my lord, instructed to the East Coast Railway.
Mr. Will you please read the whole sentence. This is your statement. This is not the direction. The petitioner alleges disobedience of this court's order dated 7/4/2021, whereby WPC number 10620 of 2018 was disposed of, read with an order dated 1/11/2021, passed on an interlocutory application, that is IA number 14707 of 2021, filed after disposal of the said writ petition. Full stop. The order dated 7/4/2021 reads as under. Full stop. On close reading of paragraph 2 of the said order, we find that there was no positive direction issued to any authority for to be complied with. So stop. Next. The order dated, the next order. Order dated
Page 28, 1/11/2021.
1/11/2021 reads as under. So stop. Next. We are of the considered view that a case of disobedience of a direction or order of this court can be made out only if it is shown that there was some order or direction issued by this court. So stop. In the absence of any direction issued by this court, in our opinion, no case of disobedience of this court's order is made out. The contempt proceeding stands stopped accordingly.
I pray liberty if any sort.
It goes without saying that the petitioner shall be at liberty to pursue a remedy in accordance with law.
Published.
Yes.
Item 66.
Well, 66, my lord. Regarding payment of compensation under the Land Acquisition Act, in the, my lord, affidavit filed by the LA collector, the direction is given to the OP number 5, executive engineer. So it is, my lord, only direction is given on page 13, my lord. Page 13 of the so-called affidavit. So page 11 and
No,
also.
where is the order?
I pray, partially it is being carried out. So, partially it is being carried
there
out.
was the direction to dispose of the representation. The LA collector had disposed of the representation, directed the engineer who has taken over to pay compensation or purchase. So
the
it has
direction
been,
was for disposal of
Yes,
representation. That
yes,
has
ma'am.
been-
I pray. So liberty to approach the rural.
The petitioner shall, however, have liberty
To approach the executive engineer, rural works division.
to approach appropriate authority if he has any grievance in relation to payment of amount of compensation.
As per direction of the mayor.
Item
Collector
67.
has given direction. Obliged, mayor.
67.
no, 67 matter is pending before the Supreme Court. Similar matters lordship today disposed of. Mr. Bisai, who is the petitioner, he has stated that he may not be there. So lordship can say that in view of that fact.
After.
SLP is pending. So
Whether we should pass the order in her absence or not.
our lordship will call it at the holidays because he is not there.
No one appears. Yes.
Item 68.
Item 68, I am for the appellant, my lords. My lords, notice was issued on the last date, and my lords, I pray this matter be taken up after vacations. The noting says that the post has been delivered. Yes, my lords, after vacation.
After.
Grateful.
Item 69.
My lord, I am appearing for the bank. Please. In
Yes.
item 68. 68.
Item 69.
69, my lord, on behalf of Mr. Dasman, can taken after vacation.
After.
Item 70.
Yes.
I am for the petition. File taken up after vacation and
I have already complied the order. And as per the direction of this honorable court, my lord, we have reinstated and paid the 50% of back wages and 100% back wages from the date of 2014. He has some complaint calculation of the. So he
That
may-
he can raise. That he can raise.
My lord.
Later, the order has been complied with.
serve copy and file objection, my lord.
Give him a copy.
I will serve a copy, my lord.
No.
I have taken up after vacation, my lord. But there is a financial.
Let us see the order then.
Single copy, my lord, will not save.
Where is the order?
My lordship, paragraph.
Where is the order which has been violated?
Kindly.
Where is the order which has been violated?
59 2023.
I order dated 15/9/2023, my lord.
So you were the petitioner.
I-
So your writ petition was dismissed.
My writ petition allowed. Directed to pay the benefit as per passed by the labor court industrial in dispute miscase 48 of 2015.
No, writ petition was not filed by you. Writ
With the
petition was
lordship
filed by.
permission, my lord.
All right. So writ
The
petition was dismissed.
corporation was challenged that order.
All right. So have you complied with the order passed by the presiding officer, labor court?
My lord. We have reinstated him and also
So
paid.
what was the direction?
Direction to reinstated and direct to pay the applicant 50% of the wages and reinstated him, my lord. We have reinstated him
My lord.
and also pay the 50% back wages till 2014
and 2014 to
And what happened to the execution case?
execution case was also disposed of, my lord. For that reason, my lord, writ petition was dismissed by this honorable court. This pendency of this writ application, my lord, that execution case was disposed of. So,
my lord, kindly see my calculation sheet, my lord. And see,
Calculation
page
sheet.
14.
We will give you liberty. You can raise calculation. We cannot consider in contempt proceeding.
My lord, as per honorable court's order, not implement the order. In term of the ID miss case, and in term of the ID miss case order, they are not implemented.
Where is the ID miss case?
ID miss case, my lord. 45 of 2015, my lord. Direct order party, the miss case B and the same is allowed in part on contest against the OP. The OP is directed to pay the applicant 50% of others from his date of termination, that is 29 to 1994 till 29 to 2014, along with 15% interest thereof. Whole wages of 750 per month, along with interest 15% thereon from 30 to 30 February 2014 till reinstatement.
So this has not been done.
In the term of ID miss case, they are not done. So,
we have already reinstatement, and as per the direction of 750, we have given, my lord. Your lordship.
Contemners, list this matter on June 2nd week as a second, 24 to 28. So as to enable him to file compliance affidavit.
My lord.
In the present case, that there was no prior approval obtained for construction of the said two pillars. We see no illegality in the order passed by the learned single judge dated 4/1/2022 in WPC number 23753 of 2013, whereby learned single judge has declined to interfere with the order passed by the appellate authority under section 91 bracketed 2 of the ODA Act, affirming the order passed by the competent authority under section 91(1) of the Act. We are of the considered view that if a construction is made in absolute and flagrant violation of the statutory provisions under the Development Authorities Act, rules, regulations, the necessary consequence is to order its demolition. An affidavit has been filed in this case by respondent number 5, referring to this court's order dated 1/2/2022 passed in this case, wherein the appellant's undertaking to demolish the two pillars has been recorded. It has been stated in the said affidavit that only 80% of the pillars have been removed, keeping its base intact, and has made the dismantled pillars blocked the free access of respondent number 5 over his land. In the present intra-court appeal, we do not intend to enter into such controversy, which should be looked into by the competent authorities under ODA Act in accordance with law.
I agree.
Case submission item number 1, CUNTC 646 of 2011.
Yeah, these are old matters.
Old matters, I don't think nothing survives because
this contempt application filed in 2011, alleging disobedience of an order of this court dated 5/8/2008. There is the order. In WPC number 8857 of 2003 appears to have lost its efficacy with the passage of time. First off, there is no representation on behalf of the petitioner. This contempt application stands disposed of. These contempt. Huh? This contempt. Oh, okay.
290/2004.
Again, ma'am. 24/9/2003. Order dated. Yes.
Item number 2.
Twenty-six.
Seven.
7/2012. Order dated. Same order. No representation.
Item number 3.
Oh. Yes, there is no representation.
No, it has been complied with because permission is was granted by the authorities for conversion. So I think it was disposed of for by order dated 22nd of March 2018. Why again it has been listed notes, I don't know.
Which one? 84 of 2013.
Yes, 184 of 2013.
Not 184, 84.
Oh, sorry, not sir. Then they've given me 184.
That is item 2. That's
The lease shows 184.
Oh, 184.
Yes.
But you have placed 84.
184. Item number 3. Ma'am.
Oh,
Item
number 84. Same order.
Item number 4.
Item 4, Your Lordship, I'm in BC. I'm appearing in person, Your Lordship. The orders have been complied. Order dated 12/4/2012 has been complied, Your Lordship.
Complied with.
My lord, I am appealing for opposite parties. Obliged. On
Item number 5.
Obliged, Your Lordship.
Same.
And the writ petition.
Oh, huh?
That the writ petition that is pending.
No, the contempt petition is.
Item 5.
No, petition is pending. Yeah, sir, also this. Writ petition has been listed. Huh? Listed. Cancelling resident certificate of 2008. Because this contempt application arises out of an order dated 22/10/2008 passed in WP, is that? Yeah, WPC number? 13436 of
2008.
2008. Relating to resident certificate for the purpose of appointment against the post of Anganwadi worker on 31/7/2008. Post of there is no representation on behalf of the petitioner in the contempt application and the petition. Full stop. With the passage of time, both the proceedings appears to have become infructuous and they stand disposed of accordingly.
I think in the REIT application, there may be some substance because
No substance, residence certificate, Anganwadi.
this one got directed to treat the certificate to be a temporary one.
The government says that they have not obliged that.
That is that, but subsequently she was allowed to join. She has been continuing since 2009. I've got the document, 2009, pursuant to Lordship's kind orders, she joined again and she is continuing. Lordship said that Anganwadi worker, no, 11 workers.
We have been informed that the petitioner is working as Anganwadi. She is working.
No, she has been allowed to rejoin after because the contempt application, she was, if you'll also kindly look at the affidavit filed by the state.
It is apparent from this court's order dated 31/2009, WPC number 13436 of 2008, that the petitioner was subsequently taken back in service.
Yeah.
Item number 6.
Yes.
No.
May 2010. The order. Come again.
Item number 7.
The petitioner has alleged disobedience of an order of this court. Dated 23/8/2010, passed in WPC number 4728 of 2010. Stop. Order complied with.
My lord, order has complied.
It is stated at the bar that the said order has been complied with. Stop. Contempt proceeding drops accordingly and stands dropped accordingly.
Item number 8.
The contempt application, this contempt application alleges disobedience of an order of this court passed in WPC number so and so. An affidavit has been filed. OJC number, sorry. An affidavit has been filed on behalf of the contemners, stating therein that the court's order has been fully complied with. The contempt proceeding stands dropped accordingly.
Item 9.
Same हो पहले का जो order.
Item number 10.
The so cause has been filed since 25/7/2016.
Complied with.
Yes, we have filed the so cause now.
It has, so cause reply has been filed on behalf of the contender stating that the court's order violation of which has been raised in the present contempt application has been fully complied with. So there is no representation on behalf of the petitioner. This application, the contempt proceeding stands.
Number 1, DLAPL 4900/2024.
Yes.
This item number 1 will only taken up after vacation, my lord.
Why? You want to remain in custody? Your client. Your client wants to
Lordship,
remain in
kindly taken up after vacation, my lord.
Why?
Lordship, today is last day of the vacation and I am out of station, my lord. Lordship, kindly taken up after vacation. It's
I requested on behalf of the petitioner list this matter on after vacation.
Item number 2.
May I please? An application for modification of order, my lord. A typographical mistake is there in the ordering person, lord. The lordship may seize the cost title, lords.
Yes.
My lord, the application arising out of Khalikut PS case number 56 of 2024.
Where? Order dated 28/2/2024.
No, my lord, in the cost title of my application, lords. Bail application.
You want change in what? Your cost title?
Name of PS, lords.
So that was your mistake.
No, my lord.
Then?
It is a typographical mistake. In my application, that is
the
there.
order.
Yes, lords.
Tell us.
My lord.
Which?
Annexure 1, page 5, lordship. Paragraph 2, your lordship. In 4th line, arising out of Bhanjanagar PS case number 56 of 2024, that will be Khalikut PS case number.
Where is that? Khalikut.
Yes, lords. Instead of Khalikut, Bhanjanagar has been typed.
PS case number. It has rightly been pointed out by the counsel for the petitioner that there is a typographical error in the order dated 28/2/2024, wherein, in the second paragraph, Anjanagar, in 4th line of second paragraph, Bhanjanagar has been typed in place of Khalikut. Stop. Similar. In the last paragraph?
Yes, your lordship. Para 7, your lordship.
Similar mistake is there. Similar error is there in paragraph 7 of the said order. Stop. The order of this court dated 28/2/2023 stands modified accordingly, which shall be read along with the present order. Stop. The time allowed to the petitioner to surrender before the court below is extended by 3 weeks from today.
Oblige yours. Deep look.
Time allowed by the said order dated so 2/8/2024 stands extended by 3 weeks from today.
3 weeks. Oblige me.
Item number 3.
Similar matters have been disposed of by your asset.
3, 4, 5, 6,
7.
and 7 also.
3, 4, 5, 6. Yes.
Highly grateful, Lords. 3, 4, 5, 6, 7. Item number 8.
Yes, anything?
Item 8.
They're just disposing it off.
Yes, your lordship may dispose of.
2011 matters. 9.
Item
8. Disposal. Yeah. Acha, you're not in. Good. His contempt application failed in 2011 alleges disobedience of an order of this court dated
4/5/2010, Milos.
4/5/2010 passed in WPC number
7088.
7088 of 2010.
2010.
Full stop. It appears that in stop there is no representation on behalf of the petitioner. Contempt proceeding stands stopped accordingly. Yes.
Item number 9.
And for the petition, no instruction received.
No instruction. It is stated by learned counsel for the petitioner that he does not have any instructions to press this application. This application is accordingly, the contempt proceeding stands stopped accordingly, has not pressed.
Item number 10.
Disobedience of order dated 2/4/2013, my lord. Till today has not been complied with. My lord, kindly see the last order, ma'am. 24/2/2020.
24/2/2000.
20.
Where is the order? Where is the order which has not been complied with?
That is the 2/4/2013 has not been complied.
12/4/2013.
2/4/2013. In WPC number,
2000 C. Madam,
my lord.
by 2/4/2013 order, an order passed in 2009 by the cooperative tribunal was directed to be complied with. And where is this order? 9/2/2009.
That or 19 tribunal plan the order, my lord, 19/2/2009, my lord.
Where is that order? No contempt, madam.
Well,
No contempt is made out.
yes, my lord. Thereafter, I am filed the writ application against that order, my lord.
Since 2009 order, you passed and which order? You filed writ petition against which order?
WPC number 12587 by 2011, my lord. Against that order. That writ application was already disposed of, 2/4/2013.
If
I'm
we are
telling-
seeing that, please come to paragraph 2, your paragraph 2.
Yes,
The writ petition is disposed of with a direction to comply with the order dated 19/2/2000. So where is this order? In dispute case number 3 of 2004. If there is no impediment, that is also conditional.
that is the order with me, the tribunal order.
Where is the
Corporate-
tribunal's order?
Mm.
Let us see. issue notice. Oh, he saw the other side.
I think somebody was referring, he has referred.
Pitki bhuya some.
All right. There is no counsel for the petitioner. There is no
Item 10 is the officer representation.
the opposite party despite service of notice. Let's this matter on after vacation, July. Yes.
Item 11.
11 has been complied with now, so.
Complied with.
Letter and spirit.
Here, I'm for the OP number 3. 11 item.
Yes. WPC. What is this 11 with WPC?
14181.
4189 of 2009.
That will dispose of it, so.
That was also disposed of. Contempt was pending.
Dispose of. All right. Yes.
Item 12.
There is no representation on behalf of the petitioner. This application, this contempt petition filed in 2015 stands disposed, stands dismissed. Oh.
Happy vacation.
Same to you, all of you.